of my lord, the station, my lord. This matter may kindly taken up next week or my lord there.
Okay, listed in next week as paid for by the council for the petition.
Kindly oblige your lordship.
May I please your lordship? Lordship, in item number 4, lordship, we have filed an affidavit in opposition on yesterday, lordship. Lordship, record may be called for.
Okay, this will not be before me. It will be some other bench. The affidavit filed by the respondents be tagged with record. This is the matter before any other bench without me.
Lordship, earlier it was taken by this, your lordship. Earlier, this was taken by your
I can't take off. There is a reason.
lordship. Oblige.
Item number 94, madam. But that matter, where the account was freeze of a car dealer, money laundering act. After getting the notice, now they have allowed us to operate there. Keeping that particular disputed amount as real. So I like to withdraw the request.
94.
Yes, 94 orders.
Okay, 94. So who is for HDFC Bank?
No, nobody has appeared. No.
So but there is a HDFC may be affected.
We have made an undertaking that we will withdraw this.
Oh, okay.
today. Otherwise, then it won't be affecting them.
Oh,
They have
okay.
allowed us to-
Council for the petitioner and HDFC Bank are present. HDFC Bank is respondent two.
Yes.
Number 2. Present. Mr. B. Upon instructions from Mr. B. Govey, then council for the petitioner has submitted that upon receipt of a notice issued by this court on the last date, the operation of the bank account has been permitted, and therefore he has instructions to withdraw this petition. Prayer is allowed. Matter is dismissed from withdrawal.
I'm okay.
Yes.
May I please, my lord? My lord, I am mentioning item number 52, my lord. Here I am appearing on behalf of respondent number 2. Lordship, my affidavit is ready, but the concerning deponent is out of station. So lordship may kindly pass the matter for 2 weeks, lordship.
Okay, you have informed the other side.
Yes, lordship. Other side
Okay.
is here.
With consent of the other side, Ms. BL Singh, then counsel for the respondent number
2, lordship.
2 has submitted that. The place for is granted 2 weeks time to file affidavit in opposition to the matters. List after 2 weeks.
Are we allowed to call for the petition?
Lordship, I'd like to mention item number 10. Lordship.
10.
Yes, my lord. My lord, senior counsel, DCK Hajarda is not well, my lord. He's not present today. So pass over the matter for a week.
List after a week as prayed for well and counsel for the petitioner.
My lord, I have another request. My lord, the WPC 3233 and 3247 of 2023 and today's item number 10. All 3 matters are same, identical.
Motion, I am not listing with any other matter.
No, my lord, on the next date, all 3 matter may be.
I am not taking up motion along with any other matter. Independently, it will be taken up. Motion matters I am not tagging. For the part of hearing, I understand. But in motion, you want to tag matters, I am not doing it.
Obliged.
Please, your lordship. Lordship, with the consent of the other side, I beg to mention item number 28 to 32. Lordship may kindly grant us some more time to file our affidavit and let the matter be listed after vacation.
28 to
32.
32.
Yes, lordship.
You're taking consent of the other side?
I'm appearing on.
Okay. Now, both sides are represented. On the prayer made by Ms.
We Shohei on behalf of Mr. J. Chutia.
We show on behalf of Mr. J. Sudhir and standing counsel for KAC. Matter stands adjourned today, list after 2 weeks. As an interim order operating, interim order past date stands extended till the next date of this thing.
Deeply obliged, lordship.
Obliged, lordship.
Yes.
Lordship, may I please? My matter relates to the Kilsako bill eviction. So today it may be taken because the urgency has been explained by my last council.
Okay, permitted.
Right.
May I please, lordship? Right, as soon as item number 52, lordship. 52, 52. My senior is out of issue, kindly adjourn the matter.
52, somebody has already taken an adjournment. Next.
If I please, lordship. I beg to mention item number 23. I representing Andrew Happiness, so he's outstation. Could you kindly adjourn the matter?
23.
Yes, I can.
List after a week as paid for by learning council for the petitioner. 23.
Hello, miss.
I like to mention one matter for listing urgency is that one private market, the Panchayat has issued a notice for settlement. For settlement of our, on our land, there is a private market, but the Panchayat issued one notice for settlement.
Okay, Monday.
Monday. Only.
Yes,
So if you policy, not actually, my lord, that's it. Item number 9. So the typographical error is not good, and in paragraph B. Here, there being 20 instead of 20.
yes, I can hear you. After any person, right? Put on your speaker is off, I think.
On, my lord.
Yes,
My lord, I seek to correct, my lord's indulgence, to correct in item number 9. The inadvertent typographical error in the paragraph 3 and the synopsis. What is written as 27 actually should have been 3. That is,
you want to correct it?
but my lord, if my lord allows.
Okay,
Obligement.
yes,
May I please, your lordship? Lordship, I beg to mention item 69 of today's daily list, lordship. We have filed an I in this matter. The I has not been tagged, so kindly the matter may be tagged along with the I on Monday.
just on Monday, along with, I filed by? Who has filed it?
Petitioner, lordship,
By the petitioner, okay.
obliged.
Next, please, Elder. We have to mention for listing the matter for extension. Some urgency is there, lordship. Earlier listed, but not listed.
Okay, give it to the court master. Yes,
May I please, your lordship? My lord, I were to mention item number 21.
yes,
My lord, I may be allowed to do this petition.
21.
But my lord, what happened is it relates to Parghat under Anchalik Panchayat. All along Anchalik Panchayat was giving the settlement. Last time also, Anchalik Panchayat gave the
No,
settlement.
you want to withdraw it?
I want to do with liberty, my lord, because my lord, meanwhile, it has been shifted to the IWT.
Okay. Upon instructions, Mr. J. Malal and counsel for the petitioner seeks to withdraw this petition with liberty to approach again. Here is allowed, matter since dismissed on withdrawal with liberty as prayed for.
No, sir.
Daily list item number 1, motion.
My lord, in this case, my lord.
Demarcation will issue a notice. Nothing more can be done.
Yeah, but the last occasion, they were inspect,
My lord have directed us to file affidavit by bringing the re-verification report, lordship. Lordship, I have seen the file of communication gap is there, instruction is here, lordship. So lordship may issue formal notice, in the meantime, we'll file affidavit, lordship.
All sides, including the petitioner and the petitioner, comma, all sides are represented. Mr. A. Goel, an additional senior government advocate, is for 2 weeks further time to file affidavit in opposition to the matter. Next paragraph. In letter notice returnable in 2 weeks be issued. You have received the extra copies?
Yes.
yes, I have.
As all the respondents have been served with requisite extra copies of the writ petition, no further steps is required to be taken. List in the admission column after 2 weeks.
In team order,
Okay, interim order past previous stands extended till the next date of this thing.
my pleasure.
Mr. Gogoi, if
Yes, sir.
interim order is there, then we fix it after vacation. We will not be able to handle so many cases before vacation,
Yes.
immediately after vacation.
Abdul.
Yes. E-stamp,
My lord.
additional notice.
Lordship.
And
Otherwise, also Lordship is in his personal difficulties, or inconvenience of him also.
no, whatever be, but if stamp is not utilized,
Lordship.
even under this regular stamp act, there is a provision for refund.
Lordship may issue notice at this.
Only if it is cancelled, he gets 50% under the stamp act. But if it is an e-stamp, I think he will get a 100% refund.
Yes, Lordship may issue formal notice.
I mean, should. Mr. S. Datta, counsel for the senior counsel, assisted by Mr. S. Datta, counsel for the petitioner. And Mr. K. Gogoi, and additional senior government advocate appearing for the
Lordship, I am for 2 and 3 Lordship.
2 and 3, and Ms. G. Hazarika for respondent number 1.
One.
The petitioner claims refund of e-stamp, unutilized e-stamp. So this notice of motion returned within 4 weeks. Requisite extra copies of the reparation be served on the Learned State and Departmental Council in course of the day. Next paragraph. The pendency of this petition shall not be a bar for the Deputy Commissioner, Kanpur Metro, within bracket respond number 2, acting as collector of the district to examine the claim of the petitioner for refund.
Lordship.
You'll have to amend this and make it collector.
Right.
Next paragraph, instructing counsel for the petitioner is at liberty to approach the registrar within bracket judicial and to incorporate the designation of collector in the cost title for respond number 2.
Of like.
3.
Please allow.
Contractual bill.
My lord,
Okay,
this admitted amount, my lord, once check was issued, but
it's okay. I'm issuing a
My lord,
notice. I can't do anything
last
more.
quarter,
Mr. PC Day, counsel for the petitioner, Mr. J. Sukhel, and it's standing counsel for KAC. And higher education will be there. Mr. K. Gogoi is standing counsel for higher education department.
I am for small 1 Lordship.
Respond number 1. Okay.
One.
Mr. Sutya will be for
From 2 to 5,
all of them.
2, 3, 4, 5.
And
6
anybody
is
else?
the treasury officer.
Huh?
6 is the treasury
Okay,
officer,
6 is treasury officer. Treasury will be by
finance.
finance.
Their name is not some Lordship.
No, it's okay. I'll issue a notice.
Standing order
Finance will be appearing.
my lord, as per the last order,
for my-
my lord, may the respondents are directed to take instruction
Yeah.
why fresh check was not issued. Once check was issued, my lord, that was a become.
Finance,
7 also mark me.
7
7,
also by. Acha.
P.
And
Nayak may be recorded, my lord. P. Nayak Lordship.
in act for respond number 6. Unpaid bill. Pendency of the replacement shall not be barred for the respondent, the concerned respondent authorities to release the fresh check to the petitioner. I
Please, my lord.
yes. Will be appearing for this border police.
My lord, Mr. Police Lordship, standing counsel of fairness. FT.
SCFTC. Mr. Das, SCFTC. After some time, let them come. Oh, Didi. No, Didi. Yes, 2 widows.
I have received instruction, my lord. Impure letter has been written, my lord.
I do. You can dispose it of then.
Yes, sir.
For Mr. R. Mazumdar and the counsel for the petitioner. And Mr. M. Shettiar and the government advocate appearing for all the respondents.
Yes, sir.
For all the respondents. Next para. The bid of the petitioner in respect of NIT dated 23/9/2022 for settlement of 58 number Accra AKRA Bill Fishery.
District Borpeta.
Borpeta. Was. Where is the impugn letter?
Impute is there, page 24, Your Honor. So we have withdrawn this and then finalize the NIT.
Was not brought to its logical conclusion on the ground that amongst two bidders, one cannot be selected. First of the said order was passed by the Joint Secretary to the Government of Assam Fishery Department. First of. Next para by the learned government advocate had produced a copy of a letter dated 2/6/2023, which is by the Joint Secretary to the Government of Assam Fishery Department, which is reproduced here in below. Full stop. Accordingly, it appears that there were 3 numbers of successful bidders, and the Fishery Department was and the Deputy Commissioner from Borpeta was directed to send the minutes of the tender committee meeting for regular settlement of the said bill. Under such circumstances, the court is of the considered opinion that that as the competent authorities are taking up the matter of settlement of the aforesaid bill, this matter has become infructuous, and accordingly this.
They may finalize the tender process.
They will do it. That's why they are calling it. First, accordingly, the matter is closed with liberty to the competent authority to bring the settlement of the said bill to its logical conclusion.
But
The communication dated 2/6/2020 is kept as a part of the court.
much.
So then. But this orders would be uploaded only on Monday. Mr. Mazumdar. Orders will be uploaded only on Monday. It's okay, but I'm just telling you, few orders may be left out.
On the last occasion, our instructions were sought regarding whether
Bus terminus.
bus terminal was fully functional and whether the decision was taken as per rules. The affidavit, I have brought the document on record and quoted the rules also at page 67. Because this area is covered by the rules itself.
Let me examine it. It's a voluminous thing. I don't have time to read today. We'll take it up at 2 o'clock. In the tiffin time, I'll read it. I would not spend more time today.
Lordship may fix it day after tomorrow also.
No, let it be finished when the matter is here.
In fact, Lordship may kindly have a look the last page, my lord, for a moment, last page.
I'll see it when I examine, because I don't want to spend time now. I have a long list today
At 2.
at 2 o'clock.
Keep your-
9.
Chamber. This will have to be stayed. Royalty with retrospective effect can't be given. Financial, what you call,
Before that.
My lord, in fact, the amendment itself says it will be it will be applicable to only fresh tenders. And admittedly, mine is
it's
a
okay,
old
Mr.
tender.
Should you want to say something?
Lordship can look into National Highway Act. Just for a moment, my lord, National Highway Act 1956.
Yep. Just read slowly. In the meantime, I'll get the book. Read slowly.
Section 3D. On the publication of the declaration under subsection 1, the land shall vest absolutely in the central government free from all encumbrances. The land will vest to the central government and the work can only be started from the publication in the notification in the section 3D. That notification was published on 15 December 2021.
Yes.
Notification under section 3D of the National Highway Act in respect of the land on which the petitioner's contract is there, that was published on 15/12/2021. And the rule was amended, my lord, on 7/10/2021. After amendment of the rule, the contract of the petitioner, though the contract was signed before that, my lord, that can only be executed, my lord, or the work can only be started when the land is vested with the central government. So there is a provisions in the, my lord, terms of the contract, my lord, that the change of law, there's a definition of change of law, that is, my lord, in the page 58, annexure 3A, change in law.
58.
Page 58, change in law. The relevant page is page 78. Relevant is definition is change of law, page 78. But
Yes.
change in law means the occurrence of any of the following after the base date. The modification of any existing Indian law. B. The repeal, modification or reenactment of any existing Indian law. And the Assam Minor Mineral Concession Rule was amended in 2021. Notification was published on 7/10/2021. So if any change in law is also there, it is in the contract that, my lord, the contract price that can be modified, my lord. And that is, lordship may get it on, my lord, page 168. Roman 4, page 168, Roman 4, the contract price. May I read it? The contract price shall be adjusted for increase or decrease in rates and price of labor, cement, plant, machinery and spare, bitumen, fuel, lubricants and other material
You are showing
inputs.
page 158.
168,
60, no.
Roman 4.
Yes.
Well, may I read it?
Yes.
The contract price shall be adjusted for increase or decrease in rates and price of labor, cement, steel, plant, machinery, we are not on that, and other material inputs. That is, my lord, mineral minerals, that the earthworks and the boulders, that is a minor minerals, that is the other material inputs. If the other material inputs, then the price, contract price can be, my lord, increased, my lord. So it is between the petitioner and the respondent, my lord, NSI authority, my lord, contract. We are only concerned with the, my lord, levy of the royalty, my lord, on minor minerals, my lord. That if the contract is there between the parties and the price can be increased, then definitely the price which is entitled by the autonomous council that can be paid. That is my submission, right?
No, just because you see number one, what is the date when this amendment came into effect?
My lord, it effect on 7/10, it gather publication on 11/10/2021, Annexure 4, page 220,
Page
page 220,
220.
Annexure 4. Notification dated 7/10/2021, published in the Gazette on 11th October 2021.
Yes, and where is the date notified here?
And my lord, that particular provision is, my lord, that it will not applicable only new tender, that is page 223, Roman 5,
Page 2 to 3.
2 to 3. The
Roman
rates
5.
as appended in the third schedule and process as prescribed above shall be applicable to the fresh tenders only. So that is the point only. So the new rates came into effect from 11/10/2021. Whether contract agreement executed prior to that, my
What
lord.
is the full name of BDM and BC work means?
My lord, we are concerned with 7.
Okay,
New road
7.
construction work with bitumen work, 6%.
Just
And the other is, my lord, 9, serial number 9. Art work, 9%. So we are claiming, my lord, the amount on that basis, my lord. Though the, my lord, tender was issued, contract was executed prior to that, my lord. But as there is a change of law is there, and the provisions of the contract price can be revised. So, my lord, there is no bar, my lord, regarding that it can be revised or modified, my lord. And the contract executed between the petitioner and the NSIDCL, my lord. We are only claiming the, my lord, royalty, my lord.
Yes, Mr. Goswami, I'd have to hear you then.
Well, let me start from the beginning. Otherwise, being a petitioner, I will be prejudiced just if I have to only reply to the respondent, my lord. Your lordship will kindly perceive that this is a tender. The work is relating to widening and improvement of the 4-lane, a particular stretch which was given to us. Now, few dates that are relevant, my lord. I may just indicate the dates before. The NIT is dated 19/2/21. The tender 19/2/21. Your lordship will kindly take note of it.
Yes.
19/2/21. Then the letter of acceptance that was given to us is at page 56. That is 31/3/21. Your lordship may for a moment kindly take page 56. Now, your lordship knows that before a person places his bid, he will take into account the relevant factors before quoting his bid. Here, since the work relates to reconstruction and improvement of the road, the prices relating, the royalties relating to earth, royalty, everything has been taken into account and a bid has been submitted. Thereafter, at page 56, the bid is accepted. If I may just read only one paragraph, the first paragraph, the date your lordship has already got, 31/3/21. Subject your lordship will find. Then, sir, this is to notify you that your bid dated 8/3/21 for execution of the widening improvement to 4-lane with paved shoulder from so-and-so of near so-and-so to so-and-so in the state of Assam at your quoted bid price. Your lordship will kindly mark at your quoted bid price amounting to rupees 141 crore 46 lakhs 40,000 only, excluding GST, has been determined to be the lowest evaluated bid and is substantially responsive and has been accepted. Thereafter, a contract has been executed between the petitioner and NHIDCL as the project relates to them. That contract your lordship will find at page 58, which is dated 28/5/21. Your lordship might kindly take a note of the date, 28/5/21 at page 58. At page 58, your lordship will get And at page 73, it starts. The party's name, the date is at page 72, and the party's name are reflected at 72. Has your lordship got it? This is dated 28/5/21. Now, if I may just pause for a moment here, my lord. Under the unamended Assam Minor Minerals Concession Act 2013 rules, my lord, at that time, the rates of royalty is based on the quantity. So if we have to make an assessment, this much of quantity of earth we are going to extract. Accordingly, we will seek for permission. Thereafter, the permits are granted. Now here work started according to us on 12/7/21. And thereafter, if your lordships find, I have given example where they have been issuing us permissions. These are annexure. The permits your lordship will find from page 213, and we have almost paid about royalty of 93 lakhs. Now your lordship will come to the amendment. Now what has been amended? Let us see that, my lord. This amendment comes on 7/10/21. Your lordship may kindly have page 220 for a moment.
I have seen those.
Yes, my lord, just for my satisfaction, if your lordship may kindly come there. Because, my lord, there is no change in law. This is what I'm trying to say. An erroneous construction of the amendment has been tried to enforce, which is not permissible. Absolutely unconstitutional. Your lordship may kindly have page 220 for a moment. Now, your lordship will see amendment of Rule 5. Has your lordship got that?
Yes.
My lords, I may just read it. In the principal rules in Rule 5, for the existing, the sub-rule 3, the following shall be substituted, namely, the lordship will kindly see the minor minerals. The first is not applicable to us because this is by government agency. Second paragraph. The minor minerals, when shall be used or consumed by government agencies, the rates of royalties shall be deducted as per the rates prescribed in the third schedule. So now they are saying that as per third schedule, the rates will be deducted. Then for a moment, if your lordship comes to the next page, subparagraph 4, your lordship
We
will
can
kindly.
just cut short and say that page 2023 subclause 5 says that it will be on fresh tenders. That is your entire argument.
Correct.
I can guess that
Correct.
much.
Correct, because
Hmm.
this is not a fresh tender. Now, what are they trying to say before your lordship is that the work have commenced later. Work commencing, land vesting, these are not relevant. The legislature have said it. It kindly sees up paragraph 4. The rates
it's okay,
as
but
appended
you
in the
see-
third schedule and
Mr.
process
Goswami,
as prescribed shall
Mr.
be.
Goswami,
My lord.
you see, under the tender contract, whatever the interpretation is, you are giving you the stay immediately, but it will be between you and the NHIDCL.
Well,
If the NHIDCL agrees to enhance the the rates,
My lord.
In the existing tender also it will be applicable. If they don't do it, then you are saved under clause 5.
True, my lord, that perhaps that is why till now we have not got any demand from NHIDCL. And my lord,
No,
one
no,
more-
it will never be, it will be to the user.
correct. Well, the other important thing, my lord, under the NHIDCL, just for a moment, your lordship has since my friend has already shown page 78, just for my satisfaction, if your lordship kindly see 96. Now, 96 of the contract agreement says the contractor, has your lordship got it? Page
Yes.
96. Just for my academic satisfaction, my lord. The contractor shall comply with all applicable laws and applicable permits, including renewals as required in the performance of its obligations under this agreement. Now, what is applicable law is defined at page 77. Your lordship may kindly have that for a moment. Applicable laws. Applicable laws means all laws brought into force and effect by the government of India or the state government, including rules, regulations, and notifications made thereunder, and judgments, decrees, injunction, writs, and orders of any court of record applicable to this agreement and the exercise, performance, and discharge of the respective rights and obligation of the parties hereunder, as may be in force and effect during the subsistence of this agreement. So under the applicable laws, my lord, and most importantly, the law doesn't change.
No, man, see, Mr. Goswami, I am tied up today.
My lord.
We are giving an interim production, but it will be subject to
Very
the,
well,
between you and the NHIDCL.
My
If they agree to
My lord,
modify your rates, you won't have any complaint.
deeply obliged.
You can't always say that, yes, no, I'll go and do the same rate, when they are ready to enhance the rate.
No, my lord. Provided the law, they are
It's a-
trying to
it's a question of
enforce the law
interpretation.
because
Fiscal-
it is the executive committee's decision.
Interpretation
they
of
have-
fiscal laws are there.
My lord, the interpretation will come only later, my lord. First, the law is very clear. There is no doubt. There is no doubt that it is only applicable to fresh tenders.
That's okay. It's on
Now,
a motion
if there is
stage.
an ambiguity,
We are
then the
not,
question
we
of
are not hearing
interpretation
it.
will come.
We are not hearing it.
My lord.
Heard Mr. K. Goswami, the senior counsel, assisted by Mr.
A Sandilya. A Sandilya.
A. Chandelier, and counsel for the petitioner. Also heard, CGC will be appearing. Mr. Gogoi. Mr. K. Gogoi, Leonard, ASGI appearing for, sorry, CGC appearing for respondent number 1. Mr. Sibarwal, and standing counsel for respondent numbers 2 and 3.
Right.
Mr.
4 to 8.
And Mr.
appearing for
J.
4 to
Supial, and standing counsel for KAC appearing for respondent numbers 4 to 8. Next paragraph. Challenging the retrospective effect of enhancement of royalty by the impugn communication dated 31/3/2023. The present writ petition has been filed under Article 226 of the Constitution of India, claiming that the enhancement of forest royalty by notification dated 7/10/2021, published in the official gazette on 11/10/2021, was excluded by virtue of clause 5, Roman 5 of section 4 of the, rule 4 of the amendment to the rules of the Assam Minor Mineral Concession within bracket amendment bracket close rules, 2021, right? Notice of motion return of evidence.
It's 5-3, I think, not, the rule is 5-3, my lord.
No. Gazette says clause 5 of that.
Yes, clause 5, clause 5.
Gazette says clause 5. We should notice the motion return of evidence so and so 4 weeks. Requisite extra copies of the writ petition be served on the runner CGC, State and Department Council in the course of the day. Next paragraph. Heard all sides on the prayer for interim relief. Stop opposing the prayer for interim relief, the learned standing counsel for AAAC has submitted that the gazette notification was issued on 7. Notification was issued on 7/10/2021, which was published in the official gazette on 11/10/2021. This 1512 is what?
Notification under section 3D
Yes,
of
sir.
the National Highway Act, hasting the land to the central government.
And the notification under section 3 capital D
Capital D.
of the National Highways Act And that by virtue of, the land concerning the national highway was handed over to the, was vested with the
Yes, to
central
the
government
central government,
on 15/12/2021.
2021.
And accordingly, it is submitted that the amendment to the rates of royalty would become applicable on the petition. And it is also submitted that as per the is 78,
My lord, contract price shall be increased, that may be only.
78,
70,
no, which, no, not that.
change in law, page 78A. Page 78.
And it is submitted that the interest of the petitioner is well protected by virtue of the clause relating to change in law mentioned in the contract agreement at internal page 17. No, that clause you said that it will be inclusive of
168, my lord,
168.
that price
Read it.
adjustment for the works is
Read-
167.
Read with
Price adjustment for the works, page 167.
clause contained in page 106 of the internal page 106 of the contract agreement, that the price,
Contract price.
which contains price adjustment for the works clause
Can be increased.
which can be adjusted for increase or decrease in rates and price of
Other material inputs.
other material inputs, which includes cost on account of forest royalty paid. As per, be that as it may. As the learned senior counsel for the petitioner has been able to demonstrate from clause Roman, within bracket Roman 5 of rule of rule 5 of the, sorry, rule 3 of the amending act, that the rates as appended in the third schedule and process as prescribed above shall be applicable to fresh tenders only, comma, the court is inclined to provide that the respondents in the Karbi Anglong Autonomous Council shall not enforce the amended rates provided in the third schedule of the Assam minor mineral concession within bracket amendment bracket close rules, 2021, which stands incorporated in the Assam minor mineral concession rules. Assam minor mineral concession rule is of which year?
2013. 2013.
2013. Next para. Nonetheless, it would be open to the petitioner to move the NHIDCL for clarification on the for settling the issue with regard to the enhanced royalty. Taking into account the clause contained in the contract agreement for adjustment on account of increase and decrease of inputs. Full stop. The enforcement of the amended royalty would be subject to further adjudication that may be made in this matter.
DPO applies.
But there is possibility of the orders being uploaded only on Monday.
There is no other problem except that, there are letters which have been issued saying.
No, I'm
no
just clarifying
FRC
because
fee.
if you don't get the order uploaded today, because there are too many motions. Yes. Mr. Barua? Your assisting counsel was there. You want his name to be recorded or your name?
No, my name, because. in
Okay.
between
No, I
one-
don't know. I don't know. I
one-
just
one
asked
minute.
you. I just asked you.
I'm standing counsel, my name. Because.
No, you
one
were
matter
vanishing
has come
counsel.
up Before.
At that time, you were vanishing counsel. So I asked you.
My name may be so.
Okay. Item 11.
Yeah, please, your lordship.
Yes.
My lord, in this case, my lord, your lordship, my lord, may dispose of this writ petition. Directing the respondent number 2, my lord,
Yes, Mr. Gogoi.
to dispose of.
This has to be heard. He is not hearing it. 2022 matter. ADC is not hearing it.
In fact, my lord, it is pending from 2018, my lord.
18.
Yes, my lord. Earlier it was before, my lord, dispute circle officer, dispute circle, my lord. Then it was forwarded to ADC. My lord.
Well, dispose it of within 3 months.
My lord.
Mr. BK Sen, counsel for the petitioner. Ms. G. Hazarika, you will be appearing, Ms. Priya Ponto, standing counsel for the finance department.
I'm not final.
Oh, sorry, revenue department. Revenue department. Appearing for respondent number 1. And Mr. K. Gogoi, learned additional senior government advocate, appearing for respondent numbers 3, 4, and 5. Next. It is projected in this case that the petitioner had approached the on 12/10/2018, the petitioner had approached the circle officer with an application for cancellation of the name of the purchaser from the revenue records and for restoration of the name of the petitioner in respect of his share of land. Full stop. The circle officer, no, it is projected that the circle officer prepared a report and made it over to the additional deputy commissioner, Kamrup Metro, Guwahati, to pass an appropriate order. Full stop. On receipt of the records, the additional deputy commissioner, Kamrup Metro, Guwahati, within bracket, respondent number 3, registered a proceeding under memo number KRC within bracket M /302/2020/2228. And you should notice
2020, my lord, 228, my lord, 2228 is the, my lord, notice.
only 2020.
Only
Okay, 220.
2020.
Okay.
KRCM 302/202.
And thereafter you should notice of hearing to the parties on 10/11/2021 and 17/2/2022. It is projected that although the parties were present for hearing, the adjudication of the matter was not taken up. The petitioner claims that on 28/2/2022, a representation was filed before the Deputy Commissioner, Kamrup Metro, Guwahati, for early disposal of the proceeding. But there is no progress in the adjudication of the said case. Hence this writ petition under Article 226 of the Constitution of India. Next paragraph. Upon hearing the learned additional senior government advocate, as well as the learned standing counsel for the finance, for the revenue department, the court has also considered opinion that the pendency of this matter, that instead of keeping this matter pending, it would be appropriate to issue a direction upon the additional deputy commissioner, Kamru Metro Guwahati, within bracket respond number 3, to take up the adjudication of the proceedings of PRC within bracket M302 of the 2020, if required on a day-to-day basis, and conclude the and dispose of the said proceeding within an outer period of 3 months
What's it?
from the date of receipt of a certified copy of this order. Preferably within a meeting. The petitioner is permitted to produce a certified copy of this order before the respondent number 3. Bring the order to the notice of the said authority.
Highly obliged.
Well. Yes,
NIT is the earlier millet is market millet was the Hagadal hard. That was continuing the 4 parts. Now it is reduced to 2 parts. And the rate millet of the hard millet it was 90,000. Now it has been increased on black 50,000. On these 2 points.
it's a policy decision. What can we do? Whether there will be 1 fishery or 10 fishery is not the court's concern. It's not a fundamental right to have only 1 fish market.
Now they
Unless you can show that there is a fundamental right.
4, now it is reduced to 2.
No, it's okay. If you can show that there is a fundamental right to have 1 fishery, I can understand. It's a decision of the government or the authorities to have 1 fishery, 10 fishery, whatever they feel like.
And rate also millet that there is millet 80,000. Now it is 1,80,000. That is public will suffer.
We can't help it.
Government bid millet.
We can't help it.
Lordship, may kindly read paragraph 15, my lord.
You see, earlier when I was in school or college, there were small time contractors doing piecemeal work in national highway, in the state highway. Correct? And many of my friends were very happy contractors doing small works. Now there are central, what you call procurement. The highway contracts have gone from few lakh rupees to few 100 crore rupees. But that is a policy decision.
It become a Monday minute, so I take instruction and
I think because if you press this, I'll have to dismiss it. This is a policy decision. I can't.
Right.
Okay,
In the meantime, I'll take instruction. Tomorrow,
Monday.
Monday,
List on,
what is
give
it?
Monday. List on so. Monday. So as to enable the all sides, you just first write all sides are represented. List on so to enable the learned counsel for the petitioner to take instruction. Wednesday, okay, make it Wednesday. 14/6.
All right.
13. Yes, we'll have to stay this work.
No, it's okay. All I'm praying for is my lord's time till Monday to get my instructions, my lord.
Till Monday.
Monday, my lord.
Okay.
I'll take the
Okay.
relevant instructions.
Let him get on Monday. Okay. All sides are duly represented. At the outset, Mr. B. Chaudhary Leonard, standing counsel for the
For the respondent
APDCL.
number 5.
Within bracket respondent number 5. 6. Time till 12/6/2023 to obtain instructions. List in the motion column on 12/6/2023. 14, okay, 14. Okay. 14. Yes.
My lord, this matter relates to
The only remedy, Mr. Mullah,
Well.
I find that you can only apply for remission. You can't extend the tender.
Look, my lord, this is not the case for extension. Whatever, my lord, so the NIT was issued for settlement for a period
No, you are
of
asking
1
for
year.
stay of the tender. That's why
My lord, kindly be addressed to me.
Mhm.
The NIT was issued for giving settlement for the period 1 year. Money was taken from the lessee for 1 year. The
and
agreement
allowed to
was
operate for 5.5 years.
Only 5.5 months we have got to operate the gun.
So remission,
Because, my lord, meanwhile, the settlement order was issued curtailing 3 months.
it's okay. Remission, you can always apply for remission and get back your money. That you will have to consider.
Lordship, may kindly
My
come to
lord,
page number 33 for once, my lord.
No, whatever the, your authority will have to take a
Already
decision.
deducted, my
My
lord.
lord.
Already deducted, my lord. Page number 33 may kindly be seen, my lord.
33, what deduction was made?
Lordship, may kindly come to page number 33.
33.
Yes, there is a table, my lord. The next 5. There is a table, my lord.
Yes,
Third row, my lord. Approved bid value for the year 2022-23 was 1,85,500 rupees. Then, my lord, the lease period is 1/10/22 to 36/23, my lord. Because we cannot extend beyond the panchayat year, my lord. And the total calculated bid value, my lord, can be seen, my lord.
138.
1,38,000, my lord. Already
Yes.
deducted, my lord.
It's okay. If you still have grievance, you'll have to adjudicate it.
My lord,
Your authorities will take a decision.
my lord.
My lord, as per provisions of law, appeal lines, we have submitted the appeal representation before the commissioner. That's pending. They have not.
We'll dispose it off.
For
If
extension, my lord.
if you have that ground, you can still dispose it. Why your authorities will sit over it? Okay. Where is your representation before the commissioner?
Yes, my lord, a representation your lordship will find. My
Where?
lord, Annexure 12.
Page, give me a page.
Yes, my lord, Annexure 12, I am giving, my lord, so your lordship will find that
Page
page
50.
at page 50, my lord.
Page
At page
50.
50.
50. Annexure 12. Before the commissioner, we have submitted, my lord, it was duly received. We have paid for, my lord, only for the period for which we have paid. And my lord, the NIT says 1 year period. But we have got only 5 months, 5.5 months. We have taken a marine engine boat, my lord, on rental basis for the year. We have engaged some laborers for the whole year. Now only 5.5 months we are getting, my lord. In that way, we have incurred heavy losses.
Okay. Heard. Mr. J. Malal and counsel for the petitioner. Mr. N. Goswami, government advocate appearing for respondent number 3. And Mr. S. Datal, and standing also for PNRD department, appearing for respondent number 1, 2,
1, 2, 4,
4,
5,
4 and 5.
5.
7 also.
7 also again.
4, 5 and 7. Next column. In view of the
6
order
also,
proposed to be
I
passed.
can, 6 also.
6 also, okay.
Yes.
Okay. Then, except for respondent number 3, you write 1, 2, and 4 to 7
Yes.
by Mr. S. Datta. The learned counsel for the petitioner has submitted that the petitioner had participated in the NIT for settlement of Katlamari, KTLAMARI, part Roman 3, comma 4, Roman 4, and Dhorbari, DHORBARI, to Dhubri Par Ghat. And he was settled with the said Ghat by order dated 30/9/2022. First of all, it is submitted that the tender was for 1 year and an agreement to that effect was entered on. Where is that agreement? Page?
And the agreement, your lordship will find that, and it's a 3.
Page. Lease agreement, not agreement, lease agreement to that effect was entered on 10/8/2022. Full stop. It is projected that the petitioner could operate the said ghat only for a period of 5.5 months. And therefore, the petitioner had submitted a representation dated 4/5/2023 to the Commissioner, Panchayat and Rural Development Department, Assam. Within bracket responded number 2. With a prayer to allow the petitioner to operate the said ghat for a period of 12 months in terms of the NIT dated 23/5/2022, or compensate the petitioner of the loss suffered. Full stop. Accordingly, this petition has been filed under Article 226 of the Constitution of India, as the said representation was not disposed of. Next paragraph. The Learned Standing Council for the PNRD department has referred to order dated 30/9/2022 regarding settlement of the said ghat to the petitioner, which was issued by the Chief Executive Officer, Zilla Parishad Dhubri, wherein and it has been pointed out that the approved bid value for the year 2022-2023 was 1,85,500 for the lease period. But as the lease period was from 1/10/2022 to 30/6/2023, the recalculated bid value was determined at rupees 1,38,764. And accordingly, the petitioner was required to give proportionate bid security and the first, second, and third installment to be paid to the Zilla Parishad. Accordingly, it is submitted that the petitioner has not suffered any loss as there was a proportionate reduction of the bid value by the respondent authorities. Next paragraph. In view of the nature of dispute raised in this petition, the court is of the opinion that no purpose will be served to keep the matter pending. Hence, the matter stands disposed of at the motion stage without issuance of notice on the respondents by directing the Commissioner Secretary to the Panchayat and Rural Development Department and or any other authority to consider the presentation of the petitioner dated 4/5/2023 to dispose of the representation of the petitioner within a outer period of 1 month from the date of the receipt of a certified copy of this order from the petitioner. Next, the petitioner is permitted to produce a certified copy of this order in the office of the Commissioner Secretary to the Government of Assam, Panchayat and Rural Development Department, within bracket respondent number 2. Bring the order to the notice of the secretary.
My lord, till then, petitioner will be allowed. to open-
Commissioner,
Till then, till disposal of the
No,
representation.
no.
Unless my lord,
No.
it's coming to the end, my lord, on
No.
30th/6.
Lordship, I said
No.
Commissioner and Secretary, my lord, but
30th
it's Commissioner, my lord.
Achha, Commissioner, not Secretary, Commissioner. Okay.
I mean, till disposal, my lord,
No.
because my lord, public will suffer. Public will suffer, my lord, because.
Oh, public will not suffer,
It's
don't
coming
worry.
To the end,
Public will not suffer.
30th June, my lord,
I
it's
can
coming to
assure.
the end.
No. Public will not suffer. 15.
Obliged, my lord.
Yes.
But in spite of complying with all the formalities for grant of IMFL and all.
I'll issue a notice. I'll
The,
issue a notice. Heard Mr. B.D. Kumar Lanet, Senior Counsel, assisted by Mr. S. Nandi, Counsel for the petitioner, and Mr. N. Goswami, Government Advocate appearing for respondent number 7, and Mr.
SM Hassan, Lord.
S.N. Hassan, Donald, Standing Counsel for the Excise Department, appearing for all other respondents. Number 1 to 6.
1 to 6.
The petitioner claims that he has complied with all the requirements for an IMFL license or on license. But no decision has been taken by the respondent authorities on the first of it is projected that a complaint was set up by certain interested persons to promote their own personal vested interests. And hence this petition under Article 326 of the Constitution of India. Next, I issue notice of motion. Returnable in 4 weeks. Requisite extra copies of the requisition be served on the State and Department Council in course of the day. Just add one more thing. Issue notice, including notice on the prayer for an interim relief. Returnable on so. Extra copies of the petition be served on the State and Department Council in course of the day. Next para. The pendency of the writ petition shall not be a bar for the which authority to take a decision?
It will be the district or the district magistrate of Nagaur district, Hojai Lamba. Commissioner.
District magistrate.
No, my lord, now they call it the. Addition. Hojai district, 7, respondent number 7.
Deputy Commissioner.
Yes, madam. 4 and 7. 7
Okay.
and 4. So deputy commissioner.
Respondent number 4.
4 and 7.
4. I, Superintendent of Excise, Nagaon, and respondent number 7, the Deputy Commissioner, Hojai, to take an appropriate decision in the issue relating to application made by the petitioner for IMFL loan license.
And because it has been granted, so they will not pass any consequential shifting orders without the leave of this court.
Pardon me?
But since all the formalities are completed, they will not pass any order for shifting. my
So
lord.
that I'm not saying anything. First, let them give a license, then we will see that.
May I quit? License is already
yes,
issued. License already issued.
But you are saying that it is closed.
No. After the license has been issued, they are not allowing it to operate it because of the objection of those vested interests.
license
Acha,
issue.
okay, then it will not be bar for the respondent to allow the petitioner to operate the IFO law license. Not the earlier one. Huh? Okay,
May pay for any date after 4 weeks, madam, any date.
it goes after vacation.
Yes, madam.
24/7. 16.
Madam, 24th, I have some difficulty, madam, can it be on 26th?
Okay.
Deep level.
16. Yes, contractor bill.
Contractor bill already completed or handing
Mr.
over.
Ahmed for the petitioner and Mr. D. J. Das, London.
For respondent 1 to 4, we have
Your CGC,
CC
applying for respondent was 1 to 4.
1 to 4.
Any other respondents?
No, Lordship, or CPW.
Saving unpaid contractors bill, comma, the present petition has filed under Article 226 of the Constitution of India. Issue notice returned within 4 weeks. Requisite extra copies of the petition be served on the London CEC in course of the day. The pendency of the petition shall not be a bar for the competent respondent authorities to examine the claim of the petitioner and to disburse payment if found due.
Much of
Sir, just one. In the last order, Mr. Kumar matter, huh? They say the petitioner will produce a certified copy of this. Petitioners have produced a certified copy of this order before the Deputy Commissioner will make a response number 7, bring the order to the notice of the said authority. Yes, Mr. Sharma,
Hello.
I'll issue a notice at this stage. I'll issue a notice at this stage.
My lord, Commissioner of Workmen Compensation is to be added party, my lord. I will.
No,
advise-
sir, the Commissioner, okay, I now remember. Now you see, this is employees compensation.
Yes, but. it
Why
was
not
by
appeal?
this, elected
Why
cert-
not appeal?
My lord?
Why not appeal? It's an
No.
appeal will all
No,
proceedings
no,
under
my
the,
lord, that's what I'm ready to argue on that. My lord, this is accident by Sir Circuit. What is in the evidence? The commissioner, before also on 9/9/2009 also decided the same matter, gave same order. Then we came to a court in writ. This court directed the commissioner to take evidence and give us opportunity. Evidence was taken. It turned out to be in police investigation trial also, it turned out to be a fire by Sir Circuit. But the party already they had settled out of, my lord, they were not my employees. Only gradually sometimes in 100 rupees they would work. On that day, they slept in a room by entering from the Torzabera. They were not employees. And at best, while it was accidental by electricity, Sir Circuit, the matter would lie to the electricity board. Because there is a provision in law. Commissioner, without going to the evidence and anything, when it is without jurisdiction, my lord, Rich Court has got the power. I've already my 1960 or 55 onwards.
you see, you are the owner of a tea stall, right?
I am the owner of it.
You are the owner of a tea stall.
Yes, yes.
Now, if there is an electrical accident,
Yes.
you see, if it goes to the ACB, then they have their own mechanism to pay compensation,
Yes.
correct? Now, he claims that the family members of the deceased
Yes.
claim that the deceased was your employee.
They only their claim, their evidence. Otherwise, my lord, all other evidence, including the VDP secretary, is that fire by Sir Circuit.
No, the cause of action may be whatever.
Yes.
But if he is an employee,
He is not the employee. That's what I have said.
but
In
this
the-
is the
in the-
case,
in the
no, no.
evidence also.
In a writ petition, we can't decide that. You will have to go in appeal. This High Court will entertain an appeal if you
While
come in
when
appellate
the matter is
jurisdiction.
totally without any jurisdiction, non-est order.
Then also it can be rectified in appeal.
No, my
A
lord,
writ petition will not be entertained.
it-
How
it
will I
can be-
find?
It can be entertained, my lord. You also may issue notice now.
No,
I'll
no,
have
I'm
to-
dismissing it.
My lord.
I'll be inclined to dismiss it.
No, my lord. Very interesting point I will argue.
No.
Yes, my lord.
You can argue today. We'll take it up at 2 o'clock. Let me finish other matters.
Yes.
But the order which is otherwise appealable,
Your lordship kindly come to my lord. What
No,
is the
just,
finding?
Mr. Sharma, just think. You see, a civil suit is filed, somebody says that, no, I am not a necessary party, so writ petition. Somebody made an accused in the criminal petition, he says that, no, I am not an accused, therefore writ petition.
My
Writ
lord,
petition
when
not to
we
decide
have
factual matters.
manifest error or without jurisdiction, writ lies. There will be alternative remedy. Writ lies, my lord.
Show me any authority on the point.
So, my lord, either lordship will hear today or on
I'll hear it at 2 o'clock. I have a matter fixed at 2 o'clock. After that matter, I'll hear your matter.
or on Wednesday, my lord. I'll argue.
Wednesday, okay.
Yeah, Wednesday.
No, we have absolutely no role to play, my lord.
14th.
authorities.
It's okay. If Mr.
We've been dragged here, my lord, for no reason whatsoever, my lord, because there is the occurrence or the accident is not due to an electrocution or an electrical accident. The police has investigated and found no fault. There is no electrical accident, my lord. The trial court.
It's okay. Let Mr. Sharma make his submission.
Very well.
We'll hear you.
There is no fault of none my lord except the short circuit. In a trial was held.
No, that's
Against me.
okay. That's okay. We'll decide that.
Yes.
Because I did not find here, if it is there, I missed it. Was the electrical inspector's report available?
My lord, they did not report it. What they did, my lord, they first settled it. Let me just summarize the fact, my lord.
No, I'll take it on Wednesday.
Yes.
If I hear it together, not piecemeal.
No, it's not on record because there is no electrical
No,
accident.
I don't know. I did not find it. That's
it's
why you
not
see,
yet.
I
It's
don't
not.
read matters
You don't make
very
party.
deeply.
They should report to the electricity board. They didn't report. That's what the rule says.
No,
Law
that
says.
is okay. I did not find it primarily
not
because I did not read it very
Only
deeply.
by evidence it has come.
I did not read it very deeply. I just cursory reading.
My lord, very
I did
order
not
is
find
no
it.
order at all. And my lord, what happened, my lord, annexer D, pay 30. They accepted 41,000 each. And after 4 years, they come and claim that they were
It's
employed.
okay. We'll hear you on
Yes.
Wednesday. List on 14/6/2023 that paid for by Mr. R.P. Sharma and Senior Counsel, assisted by Mr. D. Dole, Counsel for the.
And my lord, I will marry that party.
Pardon me?
The Commissioner of Workers' Compensation. He is a party.
You want to add,
R5. R5.
you want to add as respondent 5?
Yes.
Okay. Liberty is also granted to the instructing counsel to appear before the registrar judicial to implead a party is to implead
Commissioner of Workers' Employees
to
Compensation.
implead a respondent. Okay.
F5. Yes.
No, you go there, he'll do it. I've just ordered before the registrar judicial.
If you have-
18. None appears on call for the petitioner. However, Mr. S. Barwar and the government advocate and
RP Goswami, my lord.
RP Kostav,
RP Goswami,
RP Goswami, counsel for respondent
1 and 5.
1 and 5 are present. Next one. Issue notice.
In fact, before Lordship issues notice, the Panchayat seems to be a necessary party. Actually, the petitioner doesn't survive on the basis of non-janja necessary party.
I'll record that.
Yes.
But the issue is, I find has some merit.
Yes.
So I'll not, the issue has some merit. Because this is a normal phenomenon in most of the small towns. Even in Guwahati, when you come in and go out, you don't have a traveling space.
They have their own space created. in fact.
The national highways are blocked.
That's- But here there are allegations on the basis of that application that they have submitted in 2021.
I don't know, but it creates a lot of vices. It creates a lot of vices.
But at the same time, they are challenging the illegal action of the Panchayat by collecting money, and that they have done through tender. So the Panchayat is a necessary party here. So they have to
It's okay,
answer as
we'll
regards
ask them
the
to do it,
illegality
But
or
I'm not
legality of
dismissing it.
Yes.
Non-general can be rectified.
Yeah.
We give them an opportunity if they don't impede, then it goes on non-general. Non-general is not otherwise fatal. Non-present call for the petitioner, however, expense are present. Next, you have the issue raised in this petition, let a notice returnable in 4 weeks be issued. The notice including notice on the prayer for interim relief be issued. Next, for the learned government advocate has raised the preliminary issue of non-joiner of the concerned panchayat as a necessary party in this writ petition. First, the petitioner shall take note of the same. Next, para the pendency of the writ petition shall not be a bar for the respondent authorities to examine the grievance of the petitioner. The start of 4 weeks.
My lord, my senior's name may be recorded, my lord. My senior's name may be recorded, my lord. Miss MD Bora.
Achha, okay. So and so, on behalf of
Miss MD.
Ms. MD Bora, standing counsel for Transport Department. Okay.
19.
And if you notice, Mr. P.P. Mehdi, learned counsel for the petitioner.
I'm
Mr.
for standing counsel for 1, 2, and 4.
Mr. N. Goswami, learned standing counsel for respondent numbers
1, 2, and
1, 2, and 4.
I'm
And
for
Mr. S.
3 and
Barua, learned
4.
learned government advocate appearing for respondent number 3. Okay. You should notice, including notice of the prayer for interim relief. Returnable in 4 weeks. Requisite extra copies of the writ petition will be served on the Learned State and Departmental Council in course of the day. Next, the pendency of the writ petition shall not be a bar for the competent authorities to expedite the procedure for issuance of the excise license to the petitioner. The petitioner shall produce a certified copy of the order before. Mr. Goswami, before whom?
Logic.
Certified copy before whom?
Superintendent of Excise.
Superintendent of Excise, respondent number
4.
4.
20.
Deeply obliged.
This petition is being filed against an insurance ombudsman or award.
Okay. Your name?
Sujit Bora.
Mr. Sujit Bora, and counsel for the petitioner. Next paragraph. By filing this writ petition under Article 226 of the Constitution of India, 227 of the Constitution of India, the petitioner has assailed the Ombudsman, Insurance Ombudsman Award dated 9/8/2022. In complaint number capital GUW-L-008-2223-0086. By which the insurance claim made by the respondent number 1 was allowed. Next, issue notice of motion returnable notice of motion, including notice on the prayer for interim relief, returnable in 4 weeks. Give a fixed date after 4 weeks. After 4 weeks, give a fixed date. Returnable on so and so. The petitioner shall take steps within 2 days for service of notice on respondent numbers 1 and 2 by registered post PLD. To stop. In addition to usual steps, comma, the petitioner shall also serve notice on the respondent number 1 by routing the process through the registry of the court, and upon service an affidavit of service shall be filed prior to the next date of listing. Next paragraph. Having regard to the nature of grievance raised in this present writ petition, comma, as an interim measure until the next returnable date, comma, the implementation of the award dated 9/8/2022 passed by the insurance ombudsman in complaint number so and so from above, right? Complaint number so and so. Above we have given so and so. shall remain stayed. Full stop. However, it is also made clear that in the event this writ petition is dismissed, the petitioner shall be liable to pay interest on the awarded amount at the rates contained in the award. Based on so and so.
Wait, please, Your Lordship. First, may I make a prayer before the petition starts? Your Lordship?
Just 22. Yes.
May it please, Your Lordship.
Yes.
First, I appear on KVL on behalf of the respondent number 5 in this matter, my lord.
Yes. Work
And
order
that-
issued.
What?
You want to say work order is issued?
No, my lords,
Then?
that is already there, but I am led by senior counsel, Mr. I. Chaudhary. He had to appear in Itanagar today because the advocate general was required to appear in some matter. This matter be taken up on Monday, my lords? If
No,
it's not,
because you see, motion matters, I won't adjourn it to your instance unless he concedes.
My lords, although there is an interim prayer, my lord, but the learned senior counsel, my lord, he had called me and requested me that well, because the final settlement has not been issued, my lord. Only the letter of intent, and as per the rules, my lord, it takes some time for the final settlement to be issued, my lord.
So Wednesday we'll take it up.
Wednesday.
All sides are duly represented. On the chair made by Mr.
as Bishop Karma,
S. Vishwakarma, counsel for the
respondent number 5.
Curator respond number 5. Matters is adjourned today, list on 14/6/2023.
Prayer for
In the motion
interim
column.
considered on that.
No, I've, what do you call, I've not issued a motion. I'm just adjourning the matter.
My lord.
All right.
Supplemental according 72.
May it please, Your Lordship.
Just a minute, just. Yes, Mr. Roy.
Lordship, the petitioner is the owner of a plot of land
Yes,
and of which for construction of RCC building, the petitioner obtained a NOC from the GMC Lordship. That the NOC your Lordship will find at page Lordship 88 and Annexure 5.
it's okay. I'm not interested to look at the documents right now. You just tell what is your case.
My case is this Lordship. The private respondent was 7 and 8 Lordship because I had no sufficient money. So they come up and agreed to develop my land Lordship for construction of the ground plus to first and second floor Lordship. So an agreement was executed and I had given the power attorney to the builder Lordship. What he did Lordship, though in the agreement, as per clause 4.2 of the agreement, it was the duty of the builder to page 94, clause number 4.2 is of the agreement Lordship.
Page 94 clause.
4.2 Lordship.
Yes,
That your Lordship will get page 94 Lordship. Come to the clause number 4.2. Last at the bottom 4.2. That the owner shall grant to the developer and or its nominee or its lawful attorney an irrevocable general part as may be required for the purpose of obtaining the sanction of the plan and all necessary permission and sections from different authorities in connection with the construction of the building and also the pursuing and the following the matter with the Guwahati Metropolitan Development Authorities. So it was the respondent number 7, 8 Lordship that he was to obtain the NOC from the competent authority for the construction of the ground first and second floor. What he did, your lordship, he used my NOC, lordship, which was issued in my name, and he did not obtain any separate NOC from the either from the GMD or GMC laws. And he constructed building up to ground plus second, third, fourth. Ground plus 3 upper floors lots, though the agreement was only for up to G plus 2 lots, and thus violated the
He made ground plus 4,
yes. Ground plus 3 here.
3, okay. Yes,
And lordship, I gave the information to the GMC, GMD that the upper 2 floors are illegal, it is unauthorized, and it has been constructed without taking any NOC laws. The authorities did not take any action laws. Then I approached the state government, also state government's concerned secretary directed the GMC to take action against the respondent number 7 and 8 lots. And lordship, when the deviation was found, it was directed lordship, deviation was found lordship, and what the GMC did, lordship,
what was the date when deviation was detected?
demolition was.
No, deviation was detected when?
Yes, Lord.
Which page?
Lordship may come to page 179, lordship. Annexure 27. This is the surprising thing is, lordship, builder constructed the building, demolition was, notice was issued in my name, as because the developer used my NOC, lord. One 179 lordship, annexure 27.
Yes,
This is
I
the,
have seen that.
yes. It was issued in my name. I had not constructed any building. Apart from that, your lordship will recollect that Supertech judgment, Supertech Limited judgment of the Twin Tower Noida case, lordship, which 2 towers were blown up with RDX. That judgment also I am having. That judgment clearly laid down that if any building is found to be unauthorized, this should be, no mercy should be shown, it should be demolished, lordship. Our own High Court judgment is, lordship, that the court should not be a silent spectator when a building is found to be unauthorized, lordship. That judgment is, lordship. That judgment, our own High Court judgment is, lordship, 1992, 2 GLR 217.
217,
217. Lord.
para?
99. Para is, lordship. Page 221, 11 portion. The serial paragraph has not been given in this judgment.
Okay.
Page 221, lordship. Last para. Now it is admitted that construction was made by.
What is the name of the parties?
Name of the party is Mahmouda, Mrs. Mahmouda Rahman. Mrs. Mahmouda Rahman versus Abdul Halim. Abdul Halim.
Ali, how do you spell it? Abdul
Halim, H-A-L-I-M.
Halim, H-A-L-I-M. A-L-I-M or
H-A-L-I-M.
H-A-L-I-M? Okay.
So this is our own High Court judgment, lordship. Then I reply on another Supreme Court decision, lordship. This is your lordship, 2005 for SCC. page 99. Even the Supreme Court held that even regularization does not take place by payment of development charges, building ought to be demolished. Sometime Lordship GMC take the development charges, Lordship impose penalty and they regularize. Apex Court held that no, it cannot be done. Building must be demolished. And the one of the Supreme Court, Calcutta High Court judgment is Lordship. Very landmark judgment has been given by the Calcutta High Court Lordship. Second page Lordship, last paragraph. The condition of the private respondent that the petitioner does not have any locus standi to move the instant writ petition, it is not acceptable. It is the bounden duty of all citizens to abide by the laws of the country and take all necessary steps to act in accordance with the law. Any responsible citizen is always free to draw the attention of the concerned statutory authority seeking prevention of commission of any illegal activity, including unauthorized construction being carried out in a given premises. It is the noble duty of a law-abiding citizen to intimate the controlling authorities as regards any illegal act being committed or in the process of the being committed. It is practically impossible for a statutory authority to keep track of all activities that are going on in the society. The general public act is the eyes and ears of the authority. On receipt of any information alleging commission of an illegal or arbitrary act, the authorities should verify the same and then they according to the law. An objection raised by a stranger alleging unauthorized construction will be maintainable to a limited extent only to check whether there has been any unauthorized construction, provided the same is not malified and not tainted with malice. Law is well settled that the corporation may even take a step suo motu if any unauthorized construction is detected by them. Accordingly, the objection raised by the private respondent challenging the locus standi of the petitioner in filing the instant writ petition stands overruled. So, Lordship, here I am not a stranger. I am one of the parties to the agreement. Illegal, Lordship may be pleased to consider that if the building was constructed consisting of ground first, second, I got 2 flats, Lordship. But when the third and fourth floors were constructed, nothing, no proportionate share has been given. So I am the directly aggrieved party. And that latest Apex Court decision is Lordship. It is Supertech reported in. Citation is Lordship 2021, 10 SCC, page 1. Supertech Limited versus Emerald Court, Emerald Court. Honor
What is it? What is the citation?
Citation Lordship 2021, 10 SCC, page 1. This judgment was delivered by, headed by the present Chief Justice, CJ.
Okay.
Which held that in case of an unauthorized construction, no mercy should be shown and it must be demolished, Lordship. And even if a permission was illegally granted by the corporation or municipality, and if it is found that it is in violation of the building bylaws, the officer should be also penalized and departmental action should be taken. Relevant portion is para Lordship. Para 160.
Of which case?
That Supertech 2021.
Para,
Para Lordship 160. This is a very long judgment to turn it to 110.
okay. Yes, Mr. Bora.
I leave it to the civil. What's been issue notice, madam? There will respond, madam. There are involvement of private respondents also.
I'll take a step on private. I'm not praying for any stay or anything, Lord. Simply notice it.
You've given me several citations. I'll have to go through it and pass orders. And pass orders in the chambers.
Okay.
Orders will be uploaded only on Monday. Today I can't upload the orders. I have too many motions today.
I am waiting for 2 and 3.
2 and 3.
2 and 3.
Just a moment.
One also. 1, 2 and 3.
Anybody else is appearing?
4, 5 and 6.
4, 5 and 6. Anyone else?
No, no. Rest 7 and 8 are private.
7, 8 are private.
Private.
Okay. I'll go through the citations and pass orders. I'll take a break and come back. Just look, notes.
Take off.
That is good. But Mr. A. Paul, then counsel for the petitioner, as well as Mr. N. Goswami, then government advocate, appearing for respondent number
3, 4 and 5.
3, 4, and 5, and Mr. S. Datta,
For respondent
then
number 1.
counsel for respondent number 1. Next, madam. At the outset, the learned standing counsel for the revenue department has submitted that the communication dated 8/6/2023. The Joint Secretary to the Government of Assam, Revenue and Disaster Management Department has recalled the, no, the Principal Secretary, the Government of Assam, Revenue and Disaster Management Department has recalled the order dated 4/4/2023, and the matter is fixed for hearing on 26/2023 at 10 a.m. Full stop. It is submitted that pursuant to the said recalling order by another communication dated 8/6/2023, the petitioner has been asked to attend the hearing fixed on 26/2023 at 10:30 a.m. in the chamber of the Principal Secretary to the Government of Assam, Revenue and Disaster Management Department, CM Block, second floor, Dispur, Guwahati. Full stop. The learned Standing Counsel for the Revenue Department shall provide a copy of the notice to the Learned Counsel for the petitioner. Next paragraph. As the next paragraph, the court is of the considered opinion that as the petitioner has got the desired relief, this petition can be closed. It's
My lord,
accordingly.
the said case may kindly be disposed of within 2 months or 3
We'll
months.
do it now. He's fixing on 26. We'll do it now. He has understood there is a mistake on his part. He admitted, he has considered it.
No, as we are proceeding before your lordship on writ proceeding, so my limited prayer before your lordship to make a direction to.
They will do it. Don't worry, Mr. Paul. Once he has realized that he was incorrect in taking a decision, he has not, we got it. We'll do it.
Let him done means that, but
We'll do it. We have faith on him. It is hoped that the matter would be disposed of in a time-bound manner.
and I would like to place some relevant documents which are not filed at the time of filing that petition. Kindly that liberty may be granted to me. Because many documents which what we have annexed that was not annexed earlier.
Yes,
Relevant documents, if any.
he wants to file additional documents.
Yes. That liberty may kindly be granted.
Let them file that.
The
Lordship may kindly.
Learned Counsel for the petitioner gives leave of this court to move the Principal Secretary, the Government of Assam, Revenue and Disaster Management Department to they're willing to file additional documents. If such an application is filed, the said authority will consider. The communication provided by the learned Standing Counsel for the Revenue Department is retained as a part of the report.
74.
Please.
Yes,
The petitioners are aggrieved by a clause 10 of the NIT issued on 29/4/2023, Miller. Lordship will find the relevant translated version at page 34, Miller. Page 35 is the offending clause, Miller, clause 10.
page.
Page 35. This is the subject matter of challenge in the review. This clause, may I read it?
It enables them to file additional documents if there was deficient in some, if it's a high standard.
If
What is wrong in it?
This was the subject matter of challenge in another repetition, where one coordinate bench of this honorable court has held that this clause 10 is violative of Article 14 and it touches the sanctity of a tender process. And in another series of repetition where same subject matter was the clause 10 of the NIT in a similar NIT, where this honorable court, the coordinate bench of this honorable court has said that this does not violate Article 14. Now there are two diverse.
It is right, because you see, every time we get this, challenges to the tender, many a times, where one document was illegible, so it is allowed to be supplemented. At times, the, what you call, the security was not given in the form of, say, draft, it is given by way of a check. So those deficiencies
But
we
this-
find, and we
this-
always give a direction to entertain those
This
applications.
clause 10 enabling provision is only for the highest bidder and not for the other bidders.
Definitely, if one is ousted, otherwise, how can I supplement it?
Well, because if the highest bidder fails on the Miller, in Jalaluddin's case, this honorable court says that it is not the highest bidder who will be able to qualify for the tender. He has to be a highest valid bidder. So if he doesn't have the document at the time when he has submitted the document, now he can rectify it. There is a scope of rectification that has been permitted by clause 10. And that will prejudice the other bidders, Malad.
Oh.
Malad,
So
because
let us say you did not, you had we'll just take an example.
Malad,
Let us say the bid was opened in 1st April,
first of it.
correct? Now you gave a trade license which was valid till 31/3/2023.
Malad.
Now they say that now we are considering the tender after 2 months, you did not have your, when you applied for the, what you call, when you submitted your bid, you did not give your renewed trade license. Renewed trade license in a general practice takes place after 2, 3, 4, 6 months. So when somebody gets it, he now gives it. So what is the prejudice between the cost?
Malad, I'll put it this way. Malad. Suppose the bidder did not have submitted the trade license. He did not have the trade license. Now he quotes highest than the other bidders. Now on the date of filing the bid, he did not have trade license, but he has procured the trade license later on. Now because of clause 10, he will be able to give the trade license. On the date when he has submitted this application, he was not a valid bidder because he did not have a trade license then. Clause 10, Malad.
See that both the judgment case pass it over.
Malad, Your Lordship, I have annexed one. Page 46, Malad. Judgment starts from page 44. I'll directly take your Lordship to page 49, first paragraph, Malad, where in that petition, the petitioner challenged that he has not been given the benefit of clause 10. Page 49, page 49, 6.1.
Yes.
Malad, may I read? By referring to clause 10 of the tender notice, he has contended that the petitioner, being the highest bidder, was entitled to given an opportunity to submit the requisite document in case the tendering authority had found the bid of the petitioner deficient of some document within a period of 3 days. As the clause 10 incorporated the provision of forfeiture of the earnest money in the event of default to submit the documents to be asked for within a period of 3 days, the same was required to be followed by the tendering authority. But in the case in hand, the tendering authority did not adhere to the said clause. It is the contention of that the tendering authority has to abide by the terms and conditions of the tender notice, and it should not have deviated from the same. Now I'll take your Lordship to paragraph 8, Malad. The objection raised to this argument. Here it is. Page 50, para 8. Malad.
Yes.
So in so learned counsel for the respond number 8 has relied upon the decision of this court in Jalaluddin, wherein reference of another decision of this court in Durgacharan Mandal is made. He has submitted that the highest bidder means the highest valid bidder and not one who has offered the highest bid value. With regard to the responsiveness of the bid of the petitioner, vis-a-vis the respond number 8, so-and-so has submitted that the General Standing Committee of the Jilla Parishad in its resolution had clearly found that the bid of the petitioner was non-compliant one whereas the bid of the respondent was a compliant one. It is further submit contention that in the bidding process, a price cannot be the sole criteria for settlement of a market, but is the responsiveness of a bid which has to be given precedence. As regards clause 10 of the tender notice, so and so has submitted that if the said clause is made applicable in the competitive bidding process, the sanctity of the competitive bidding process, which requires fairness, transparency, definitiveness, and non-discriminatory level playing ground for all bidders would stand removed. If an exercise is to be undertaken in the nature mentioned in clause 10 of the tender notice, the same would result in a treatment of unequals as equals with a direct impact on the equality clause entered by Article 14 of the Constitution of India. The tender notice has incorporated the terms and conditions to be fulfilled by a participating bidder, more particularly clause 11 to clause 16, which requires the bidder to submit a number of documents at the time of submission of the bid. And clause 17 had in clear terms laid down that in the event of non-fulfillment of the terms and conditions incorporated in tender notice, the bid of such bidder would entail rejection. Insofar as clause 10 of the tender notice is concerned, the interpretation of such clause is to be best left to the tendering authority. He has further submitted that the petitioner has adopted to predatory pricing, which is easily evident from a comparison with the annual value fixed by the government for market at rupees so and so. The discretion is available to the tendering authority to accept a reasonable bid, which may not be the highest bid in terms of the price. In support of his submission, he referred to the Honorable Supreme Court of India in Jagdish Mandal reported in so and so. Now, your lordship will find the findings of the court, my lord. I'll start from page para 18, my lord, because the decision of incorporating the clause was pursuant to an OM, my lord, office memo, a notification. That has been discussed with the Honorable Single. Page 57, para 18. On perusal of the notification dated so and so of the Panchayat and Rural Development Department, the Government of Assam, it is found that the same was issued to all the chief executive officers. It was stated herein that in order to ensure settlement of the markets, ghat, fisheries to the highest bidder for enhancing the collection of own source of revenue by the Panchayat, the chief executive officer were requested not to cancel any bid of the highest bidder on account of non-submission of the required document as per tender notice, except court fee and earnest money, and to allow such bidders to furnish the documents before offering settlement. On a close perusal, it is noticed that the said notification dated 29/6/2018 pertain to the settlement process of market ghat fisheries at the level of Jilla Parishad, Anchalik Panchayat, and Gaon Panchayat, respectively for the Panchayat financial year 2018 and 19. The petitioner has not brought on record any notification the state government whereby the directive has also been extended for the subsequent financial years, including financial year 21 and 22. With which the present lease is concerned. On the other hand, the letter bearing number so and so, the government in the Panchayat and Rural Development Department was in respect of a process required to be followed for settlement of the market ghat fisheries under the various PRI institutions during the Panchayat financial year 21-22. The contents of the letter dated 23/4/21 is found silent on the aspect of providing time period to the highest bidder for non-submission of the required document and of granting opportunity to such highest bidder to submit the document which were not submitted with the bid. Though the said letter dated 23/4/21 had mentioned about a model notice inviting tender for the Panchayat financial year 21-22, a copy of the said model notice inviting tender has been placed before this court by way of the parties. Be that as it may, the bidders participating in the competitive bidding process
Has not
have-
been. Model notice has not been placed.
My lord,
Model notice has not been placed.
has not been placed.
Not
before
been
this court.
placed.
Has not been placed before them. The bidders participating in a competitive bidding process have no other right except the right to equality and fair treatment in the matter of evaluation of competitive bids offered by them in response to the concerned notice inviting tender in a transparent and non-discriminatory manner and free from hidden agenda. At the same time, the procedure to be adopted in a competitive bidding process by the state or any of its agencies instrumentality, which is for distribution of the state largesse in one form or the other, must have to be fair, transparent, and rational, providing equal opportunities to all the interested and eligible persons to participate in the process. The decision of the tendering authority in the matter of evaluation of bid or in awarding a contract must not be arbitrary, irrational, and unreasonable. If the matter of evaluation of a bid or in awarding of a contract has to conform to any statutory prescription, then the tendering authority must be alive to such statutory prescription while evaluating the bids or while awarding a contract which is in the nature of distribution of state levies. The decision-making process of the state or any agencies, instrumentality of a state in evaluating the bids or in awarding contract is required to keep the possibility of discrimination, arbitrariness, and favoritism out of the purview, and the same should be transparent, fair, bona fide, and in public interest. The power of judicial review in respect of the matter relating to award of a tender is for the purpose of checking arbitrariness, irrationality, unreasonableness, and bias. It is intended to check whether the choice or decision is made lawfully and not to check whether the choice or decision is sound. Though in the matter of awarding contract by the state or its agencies, price is one of the relevant criteria, but price is not the sole and decisive criteria. The maintenance of sanctity of a competitive bidding process on the aspect of fairness, transparency, definitiveness, providing an equal level playing ground field cannot be compromised with the acceptance of a bid which is otherwise not valid, being non-compliant to the terms and condition of the tender notice and was deficient at the time of submission. In the light of the discussion made above, it is clearly emerged that clause 10 is a standalone provision and the procedure prescribed therein is incomplete to the other terms and conditions incorporated in the tender notice. Clause 17 of the tender notice has internally set forth in the event a bidder does not meet the terms and conditions incorporated in clause 11 to clause 16, the bid would entail rejection. Clause 11 to clause 16 of the tender notice required the bidder to submit a number of documents described therein to accompany the bid. If the procedure indicated in clause 10 is required to be followed as has been contended on behalf of the petitioner, one could also contend that the same would be an abhorrent to a competitive bidding process, as there would not be any fairness, transparency, definitiveness, and rationality. On a way of interpretation of clause 10 could be that a bidder at the time of submission of a sealed bid in response to the tender notice need not submit any other document except the prescribed tender form, court fee of rupees so and so, and earnest money as quoted in the tender notice. If his bid value emerges as the highest, then he would be called by the tendering authority to submit all other requisite documents. If he manages to submit all the requisite documents within the stipulated period of 3 days, then he becomes the highest valid bidder, which he otherwise at the time of submission of bids was not. In the event he fails, his bid would be rejected at the cost of forfeiture of the earnest money. One could visualize a situation where about n numbers of bidders participate in a response to tender notice by submitting only the court fee, stamps, and earnest money, and if other granting opportunity to this n number bidder to submit the documents a period of 3 days, each all of them fail, then by that time a period of n 3 days will expire, whereas the period of settlement is only for 1 year. If all the bidders who have offered higher bid values are to be given opportunity of the meeting the deficiencies one after the other, then there would be no requirement of meeting the eligibility criteria by the bidders on the last date of submission of the bid. There could be many others like situations all of which cannot be envisaged now. From the above, it is certain that if clause 10 of the tender notice is made applicable, then the same would for the benefit of the bidders whose bids were invalid at the time of submission, and the same would be to the prejudice to those bidders whose bids were compliant to the terms and conditions of the tender notice at the time of their submission. The issue of acceptance or rejection of a bid of the bidder is to be examined not only from the point of view of both the tendering authority and such a bidder, but also from the point of view of all other participant bidders. The said situation is clearly opposed to the principle of equality enshrined in Article 14 of the Constitution of India. The same would clearly be discriminatory in as much as it would result in an anomalous situation where unequals would be treated equally, giving them an unjust benefit over a bidder who is otherwise highest valid bidder in terms of provision of the Assam Panchayat Act and Rule 4710 of the 2002 rules, merely because they had quoted higher bid value. Such a situation cannot be envisaged in competitive bidding process on the touchstone of Article 14 of the Constitution of India and in view of Rule 4710 of the Rules 2002. So, but subsequently, all these are annual tenders, and the same NIT is being repeated. Even this NIT is also a replica of the earlier NIT. Subsequently, there was a series of repetition where this clause 10 was challenged. And in that, I have found that there is one more judgment of this coordinate bench where otherwise.
Yes.
The subject matter of challenge, my lord, has been indicated in para 8. Mary,
Yes.
para 8. The learned counsel for the petitioners have immediately drawn the attention of the offending clause in NIT, which is clause 10 in 4 of the cases and clause 11 in 1 of the cases. And it is not in dispute that the expression wordings in both the clauses are exactly the same. By the aforesaid clause, it has been stipulated that the bid of the highest bidder would be accepted for consideration and the said bidder would be given 3 days time for submission of a necessary document, except court fee and earnest money deposit. And if the said bidder fails to do so, the second highest bidder would be offered the settlement with the same condition. Assailing the aforesaid clause, the submission of the learned counsel for the petitioner are that the said clause is in violation of the right of equality, as a favorable treatment has been sought to be given to a bidder whose bid itself is an invalid one. It is submitted that the importance of a quantum contained in an invalid one. It is submitted that the importance of quantum contained in a bid value would be of relevance only when the bid is adjusted to be a valid bid, and unless and until the necessary documents and criteria are submitted or made by a bidder, the bid cannot be considered as a valid bid and is liable to be rejected. It is further submitted that the said clause itself is in violation of another clause of the same NIT, namely clause 17, which is also numbered as clause 18 in few tenders. Clause 17 states that if any of the conditions mentioned in the preceding clauses are not fulfilled, the tender application is to be rejected. It is contended that in view of such clear stipulation in the NIT, the scope of consideration under the offensive clause will not arise at all, and therefore the aforesaid clause is liable to be declared unreasonable and accordingly be set aside. The learned counsel for the petitioner has tenuously argued that the highest bid actually means the highest valid bid, and in this regard, decision of this court in Mohammed Jalaluddin versus State of Assam reported in so and so has been passed into survey. The relevant paragraph of 1314, those are herein quoted below. Rule 4710 of the rule reads as follows: the tender of the highest bidder shall be accepted, and that the acceptance of a tender other than the highest bidder shall require prior and formal approval of the government. This court in WPC number so and so, while interpreting Rule 4710 of the rules by judgment and order dated 18/3/2015, has held as follows. Process in the context of a notice inviting tender encompasses within its ambit, amongst others, preparation of a comparative statement, evaluation of tenders, and rejection of tenders not conformity with the requirement of the NIT. Section 105 subclause 3, 106 subclause 3, and 109 subclause 3 also provide for examination of a tender by this General Standing Committee. The highest tender after examination and evaluation in a given case may be rejected. Once rejected, such tender cannot come into consideration for the purpose of acceptance or settlement. If the words highest bidder occurring in Rule 4710 of the rules is given literal meaning, examination or evaluation of a tender as contemplated in the Act will be rendered meaningless, and it will result in a situation of acceptance of a tender irrespective of the fact as to whether or not the tenderer fulfills the eligibility criteria and other terms and conditions. Surely this is not the legislature contemplated. The expression the tender of the highest bidder shall be accepted would, by necessary implication, and mean that the highest valid tender will be considered for acceptance or settlement, and therefore Rule 4710 of the rule has to be understood to mean that the tender of the highest valid bidder shall be accepted, and the acceptance of the tender other than the highest valid bidder shall require prior and formal approval of the government. It is submitted that the sanctity and the fairness involved in the bid process would grossly be violated by presence of the offending clause, which would bring in the element of bias and favoritism. It is further submitted that the offending clause would be an impediment in an equal level playing field amongst the competitive bidders. See, Politis learned counsel for this petitioner in WPC 3752 additionally submits that the offending clause has been adopted from a model NIT, and which itself is a subject matter of challenge in WPC 5010 of 2020, which has been instituted by the petitioner in this court, and the said petition is pending. Now I'll come to the findings of the court. The findings of the court starts from para 21. Page 18 of the order.
This, the previous judgment was not placed.
Malad, it was placed. It was placed at para 21, 20, sorry. Para 20. Malad, the judgment which we have annexed into the repetition is of a repetitioner Abdul Samad. Similar order was passed in WPC number 27 of 2022, which has been recorded in para 20 in Rafiqul Islam. There were 5 or 6 cases, malad, common order were passed in all those cases. But at that point of time, there was a writ appeal pending, which has been taken note by the coordinated bench.
What has happened to the
Now,
writ
writ
appeal?
appeal, malad, I've seen just now, malad, it has rendered infractions, malad, it has been closed. It is closed, malad, on being infraction. So the
So
question,
therefore, the
malad,
judgment stands.
so malad, the confusion with regard to which of the judgment will follow, it still remains, malad. In fact, malad, there were several writ petitions which were also writ appeals, malad, filed against the order judgment of my Lord Justice Medhi, malad. But as the term period has over or the parties were not made, so no adjudication has been done on with respect to that.
Yes.
Even number date to come. Yes, ma'am. Last date, disposal date is 16th of February 2023. Reticle 204.
Yes.
May I start from page 21. The rival submission made by the parties have been duly considered and the materials placed before this court have been carefully examined. Before going into the issue involved, this court of the opinion that the examination of the same would be restricted for only those petitioners who have locus to maintain the present challenge. In other words, the present exercise cannot be turned to be a mere mechanical one where an issue has been raised by a party who would not be in any way affected by the result of the same. In the instant case, it appears that the few of the petitioner did not even submit the bid, and so far as one of the petitioner is concerned, his bid is 13th in rank so far as the financial aspect is concerned. For those petitioner, this court is not inclined to examine the issue on merits, even if a case is made out as a result of the same is not going to have any effect whatsoever on the said petitioner. Having said that the issue is required to be adjudicated so far as the petitioner who have submitted their bids in response to the aforesaid NIT are concerned. The challenge is regarding a clause which gives 3 days time to the highest bidder to submit furnished documents in support of the bid as required under the NIT. A minute examination of the said clause would show that the liberty is given for documents other than earnest money deposit and court fee. A bid without being accompanied by court fee and earnest money in any manner cannot be taken into consideration. However, in case of other documents which are also necessary to construe the bid to be valid bid, 3 days time is given to the bidder whose financial bid is otherwise found to be the highest. This court finds force in the contention of the Learned Standing Council of the department that the objective is only to ensure maximum revenue is fetched in the tender for allotment of markets, mean mahal, etc. This court has further noticed that the point period granted is limited to 3 days, enabling a highest bidder to furnish the documents, which might in a given case not be available or could not be searched at the time of submission of the bid on the last day. The clause further stipulates that the liberty is not an unlimited one, but only for 3 days, whether the turn of the second highest bidder would come with the same condition. Such a clause in the considered opinion of this court cannot be termed as a construed as unreasonable or arbitrary, and rather the same appears to be consonant with the principles of fairness, transparency, and as a fair opportunity is given to the given to ensure that the maximum revenue is earned by the state. The Honorable Supreme Court in so and so has laid down that the employer should be given some leverage for making the decision. There should be free play in the joints. The relevant paragraph is extracted herein below. While as mentioned herein before, fair play in the action in matters like the present one is an essential requirement. Similarly, however, free play in the joint is also a necessary concomitant for an administrative body functioning in an administrative sphere or quasi-administrative sphere as the present one. Just from that standpoint of view, though all the proposals might not have been considered strictly in accordance with order of precedence, it appears that these were considered fairly, reasonably, objectively, and without any malice or ill will. The aforesaid expression free play in joints has again been reiterated in landmark case of Tata Cellular versus Union of India, wherein following has been laid down. The principles deductible from the above are the modern trend points to judicial restraint in the administrative action. The court does not sit as a court of appeal, but mere reviews the matter in which the decision was made. The court does not have the expertise to correct the administrative decision. If a review of the administrative decision is permitted, it will be substituting its own decision without necessary expertise, which itself may be fallible. The term of invitation to tender cannot be open to judicial scrutiny because the invitation to tender is in realm of contract. Normally speaking, the decision to accept the tender or award the contract is reached by the process of negotiation through several tiers. More often than not, such decisions are made qualitatively by experts. The government must have freedom of contract. In other words, a fair play in the joints is a necessary concomitant for an administrative body functioning in an administrative sphere or quasi-administrative sphere. However, the decision must not only be tested by the application of Wednesbury principle of reasonableness, including its other facts pointed out above, but must be free from arbitrariness and not affected by bias or actuated by malafide. Quashing decision may impose heavy administrative burden on the administration and lead to increase and unbudgeted expenditure. This court, in cases of Tarun Bharali versus State of Assam reported in so and so, and Jogeshwar Dole versus State of Assam reported in so and so, has laid down in the matters where revenue is concerned, the quantum is of paramount importance. The present adjudication is also to be done by taking into consideration of law laid down by the Honorable Supreme Court in case of Michigan Rubber India Private Limited Supra, in which it has been laid down that in the matters of formulating conditions of tender, great latitude is to be considered to the state authority, and such latitude is not to be interfered with unless it has been inserted with a malicious intention or to favor a particular party. In the instant case, no such malafide or favoritism has been made out, as the case clause in question is a general one, which is meant only for the party whose bid is the highest. In view of the aforesaid facts and circumstances and the discussion made above, this court is of the opinion, though no case for interference is made out, and according to the petition stands dismissed. Interim order passed earlier stands vacant. Fact, clause 10 of the NIT Mellot, if you're watching, see, it also doesn't say Mellot that only documents which were existed on the date of on the last date of submission would only be considered. Whereas Mellot, it's a settled position of law, Mellot, that the eligibility and qualification has to be on the last date of submission of the application. Now, Mellot, this clause 10 makes it very vague, Mellot. Even a person who doesn't have the qualification at the time of submission, if he becomes an highest bidder, he will get an opportunity to rely on the documents which he has procured later on. And on the contrary, the same NIT Mellot contains a clause 17, Mellot, which says if the documents which has been mandated by the NIT is not submitted, then the bid documents has to be rejected. So there is an inconsistency with this. Take one.
Okay. Okay.
In fact, my lord, there were against this order passed by my lord Justice Nidhi, my lord, there were several writ appeals filed, my lord. In fact, today one writ appeal was also before the division bench, my lord. And the grounds of appeal were that there were two conflicting views taken by the coordinate benches, my lord, and which will prevail. But in that appeal also, as the appellant participated in the tender process, therefore the appeal has not been. So the appeal has not been adjudicated, my lord. So the honorable division bench did not interfere with the judgment of the honorable single judge on the ground that because the appellant participated in the tender process and he has not made the other highest bidder as a party. So the position of law as to which view of the coordinate benches would be prevail, my lord.
What is the bid opening date?
My lord, the bid opening date. Of 12th of June 2023. The tender will be accepted till 2 p.m. of 12th of June 2023. And the tenders will be reopened at 3 p.m.
Yes, Mr. Datta, what do you have to say?
My lord.
Mr. Datta?
May I submit, my lord?
Yes.
Lordship may kindly come to page number 48 for a moment, my lord.
48.
Yes, my lord. The subject matter of the earlier judgment, my lord, the case, my lord, was different, my lord. Lordship may kindly come to paragraph 3. May read, my lord.
Yes.
Aggrieved by the order of settlement issued in favor of the respondent number 8, the petitioner has approached this court by this writ petition, challenging the same on the ground inter alia that the market had been settled in favor of the respondent number 8, despite the petitioner quoting the higher bid value than the respondent number 8. And in settling the market, the respondent Zilla Parishad did not adhere the condition incorporated in clause 10 of the tender notice. In that case, my lord, what happened, my lord? The petitioner submitted a defective document, my lord. So as they have submitted a defective document, we did not allow to avail the clause 10, my lord. Thereafter, he challenged this, my lord, and clause 10 was not challenged in that case, my lord. Those are the passing remarks only, my lord. Thereafter, clause 10 was specifically challenged, my lord, in the second subsequent case, my lord. And honorable court decided the clause 10 valid or not, and valid, my lord. Thereafter, 2 appeals were filed. One is already dismissed, and another is pending, my lord. So those cases are different, my lord. In the first case, clause 10 was not challenged. Those were only passing remarks, my lord. And lordship may kindly come to paragraph number, the page number, my lord, 60.
Issue decided can't be a passing remark.
My lord, the paragraph 22 of the earlier
It
judgment,
may
my
not
lord.
have been a matter of challenge,
My lord,
but the parties knew what was under challenge and therefore the parties participated in the hearing.
my lord.
And an issue was decided with regard to clause 10.
Then,
It can't be said that it's a passing remark.
my lord, may kindly come to page, paragraph 22, my lord, page 60 of the earlier judgment.
It's 60, yes,
Yes.
I'm there.
Paragraph 22, may I read, my lord?
Hmm.
It has been settled by a long line of decisions of the Honorable Supreme Court of India and this court that the authors, the tender document is the best person to understand and appreciate its requirements, and thus its interpretation should not be second guessed by court in judicial review proceeding. The court in a proceeding under Article 226 must defer to this understanding and appreciation of the tender documents unless there is malafide or perversity in the understanding or appreciation or in the application of the terms and conditions of the tender document. It has been observed that it is possible in a given situation that the tendering authority may have given its interpretation to the tender documents that is not acceptable to the court, but that by itself is not reason for interfering with the interpretation given. If two interpretations are possible, then the interpretation of the author of the tender document must be respected and accepted. While exercising the power of judicial review under Article 226 of the Constitution of India, the court does not sit as a court of appeal over the decisions of the tendering authority. Some references were given, my lord, thereafter, my lord. In the case in hand, the tendering authority in relation to clause 10 has sought to give an interpretation that the same cannot be made applicable in case of a bid where anomalies, deficiencies, irregularities were found in the documents required to be submitted accompanying the bid. In that case, my lord, the documents were not valid documents were they have submitted. That is why we did not allow to avail the clause 10, my lord. This is the interpretation sought to be given by the petitioner has already been dealt with here above, when it is found that the such interpretation would result in violation of so and so, my lord. So I am respectfully submitting, my lord, that the earlier case was not challenging the clause 10, my lord. Whereas the later on the series of cases were challenging the clause 10 were dismissed by the single judge, my lord, honorable court, my lord. And already in that subsequent that these cases were discussed also, my lord. Submitted, my lord, during the hearing, my lord.
As clause 10 was not a challenge in that petition, my lord, therefore the honorable court, though has observed that this is an violative of Article
This,
14.
I'll be going with the order of this passed in WPC 6902 of 2021.
Hello.
The operation of clause 10 will be suspended.
Hello.
I'll give my reasons.
In fact, lordship is very
Just
much
now,
aware, my
just-
lord,
Just
that
now,
in
just now.
my lord.
Yes,
Yes, your lordship is very much aware, my lord, in Apex Court, my lord, in Glodine Techno Serve case, my lord, 2011 5 SCC 103. Observe, my lord, that it is the discretion of the authority to accept the explanation for non-compliance, my lord. So it's by inserting clause 10, we are giving opportunity to all, my lord.
No.
Not
Which is-
not a
which is-
single
which is-
bidder, because it's
which is the decision you are citing?
2011 5 SCC 103. Glodine TechnoServe Limited, my lord.
2000?
2011 5 SCC 103. I don't have the judgment with me right now, my lord, but I have noted down, my lord. Glodine TechnoServe Limited versus State of MP.
One zero three.
103. Eleven 5 103.
Okay. I'll still go by the previous judgment.
Fine.
Stay the operation of clause 10. I'll add my results.
Highly
Heard Mr. B. Kaushik, learned counsel for the petitioner. I'll resume at 2.
My lord.
And Mr. You're also appearing.
Here you lordship, I would like a small submission, your lordship.
Yes.
In the earlier judgment. The judgment they relied upon, your lordship.
Yes.
The leases that they were claiming benefit under clause 10, which is impugned here, your lordship. In deciding that lease, your lordship, some observation was made by the learned coordinate bench, your lordship. In my humble submission, your lordship, without even making such observation, the learned coordinate bench would have decided the issues involved in that lease. And the subsequent judgment given by the another coordinate bench, here, your lordship, the clause 10 was itself under challenge. So clause 10 was upheld by the subsequent judgment by the another coordinate bench. So
my anxiety is whether if this involved is it not really not under the clause 10 was since it was not challenged in the earlier writ petition and issues involved are different. And the learned coordinate bench could have decided the list without making such observation. Whether there is any binding authority of that judgment.
It is a simple answer. The answer would be that you see, a ratio is not decided on the basis of what is under challenge. A ratio of a case is decided on the basis of the decision which has been rendered on the facts of the case. Unless you show me otherwise, we'll pass the orders at 2 o'clock. By then you can do the research. You see, the nature of challenge does not determine the ratio. That is my understanding. The ratio is what has been conclusively decided in the case. So when both the parties, you see, the advantage is, if you know the principles of order 14 rule 2,
Yes.
then what happens is that maybe an issue is not framed in a case, but that is the issue decided. Both the parties address the court on the issue, and therefore they are deemed to be aware of what is being argued. So both sides can't take a defense that the matter was not under challenge and therefore this was not argued. That is one. Second is, you see, even under the touchstone of section of Article 14, this has to go because of the reason that, you see, when tenders are opened, then you are aware of the procedure, correct?
Yes.
What is the procedure? That the bids will be opened, the technical bid would be opened at in the presence of the parties, correct? Now, an authority gets a discretion to have documents and consider it in the absence of parties. How does it not infringe Article 14?
Your Lordship, it is not speaking about absence of parties, Your Lordship.
No, it doesn't say, clause 10 doesn't say that the documents will be considered in the presence of parties.
Yes.
It doesn't say that. So it will be a subjective satisfaction of an officer.
If he is found to be highest bidder, Your Lordship, then he will
Correct.
get the
So
benefit.
therefore you do, Mr. You see, Mr. Kumar, you see, it is very easy now to understand, to make you understand. Now you see, in a tender, 3 parties set up. They form a consortium, then they bid, correct? The documents, let us say the owner name, the trade license of the proprietor is not given. 5 parties, out of 6 bids, 4 are of that consortium. They each bid 1,000 higher. They don't have the documents. Now this firm, let us say for convenience, one is a firm A, B, C, D, E, F. 4 are consortium. Now whoever gets the highest bid will bring the trade license of Mr. A. He will say the firm A is also owned by A, or let us say Z. B will say that no, I am the owner of Z, B. So everybody, without giving a document of ownership of proprietorship, gives a bid and then comes up that no, my firm may be A enterprise or B enterprise, but the owner is C. These are the documents I submit. Then what you will do? There are endless permutation and combinations. One can come up with any permutation and combination and then say that these are the essential documents. You see, I am a defaulter.
If this such situation may arise in event of absence of the clause 10 also.
No, it can't arise because then you have to give the documents of ownership.
So far as the demi bidders are concerned.
We are not talking about genuine people. It's a complex world. We are talking about genuine as well as ungenuine people. So you see, if there is a document which is on record, then it is okay. You see, some documents is deficient in some manner. I accept your argument that yes, there can be a what you call the discretion of you to enable him to update the information. Correct. That is understandable. But what happens if the document, you see, take a situation where X gives an invalid document, he is rejected. And in case B, one does not submit any document, and just because of the highest bid, he has been accepted. His documents are also taken. Therefore, the easy thing would be that in every case, people will file a bid, only financial bid, will not give a document. No scrutiny.
Your Lordship, because the prime concern is here is the earning more revenue.
No, but in this, I find the ratio of the learned single judge more acceptable. He has given,
So far as the judgment relied upon my learned.
no, earning is okay, but you will have to test the satisfaction of,
Made in that petition.
no, Article 14 will have to be satisfied.
Submission, it is in the nature of auditor dicta.
I am unable to accept it. I'll record your submission, but not be, unless you show me an authority on that point.
I would like to.
Because whenever every time I fail in the rate side, I conveniently go back to my civil roads. If I go to order 11, then I find that under test of Article 14, it will fail. A person giving a defective document is out. A person giving no document at all is in.
Paragraph.
I'll take up at 2 o'clock.
Yes. Obliged. We are relying upon a judgment here also.
Yes,
Arun Kumar Agarwal versus State of Madhya Pradesh here also.
yes.
This is the- Paragraph 31 here also.
Yes.
In view of above, it is well settled that obiter dictum is a mere observation or remark made by the court by way of aside while deciding the actual issue before it. The mere casual statement or observation which is not relevant, pertinent, or essential to decide the issue in hand does not form the part of the judgment of the court and have no authoritative element.
Yes.
Since your lordship, the observation made by the another coordinate bench, your lordship, the issue involved is different. Your Lordship. So without even making such observation, also the issue would have been decided. Your Lordship. And this, moreover, your lordship, the clause 10 is has not been struck down by the coordinate bench. It is not interfered with you. This is my humble submission.
Third. Mr. D. Kaushik, Learned Counsel for the petitioners. Mr. K. Kumar, Learned Additional Advocate General. Appearing for respondent number 1.
1 to 5. 1 to 5. 1, 2, 3, 4, 5.
Okay. Assisted by Mr. S. Datta, Learned Standing Counsel for respondent numbers 1 to 5. Next paragraph. By filing this writ petition under Article 226 of the Constitution of India, the petitioners have assailed the inclusion of clause 10 of the NIT under memo number BAP oblique Hut oblique Bazaar oblique Mean MWN Expert Mahal MAHL oblique 2023-24 oblique 331 oblique OK was dated 29/4/2023 jointly by the executive officer and president of BATRADA, BATA DRAVA, Anchalik Panchayat, within bracket their respondent numbers.
What the issuing authority? I mean.
Okay, 5 and 6.
5 and 6.
Responding of 5 and 5 and 6. Full stop. Issue notice of motion returnable in 4 weeks. Because the extra copies of the petition is out of the Learned Standing Counsel for the PNRD department in course of the day. The petitioner shall take steps for service of notice on respondent number 6 by registered post with AD. In addition, notice shall be also served by Dusty mode by routing the process through the registry of the court. And upon service, an affidavit of service shall be filed prior to the next date of listing. Next paragraph. Heard both sides on the bed for interim relief. Post stop. The in brief, the case of the petitioners is that that by introducing clause 10 in the NIT dated 29/4/2023, the authorities have given a scope to the highest bidder who had not submitted necessary documents, save and except court fees, earnest money. Only 2 exceptions. Only 2 exceptions are there.
Yes.
And so and so will be allowed 3 days time to furnish the deficient documents. First time. Accordingly, it is claimed that the benefit is only given to the highest bidder and not to all the bidders who are who had not filed proper documents. And it is also projected that the said clause, if allowed to remain, would defeat transparency in competitive bidding process. The Learned Counsel for the petitioner has submitted that the said clause will allow an unequal person to be treated as equals, and the sanctity of the competitive bidding process would be violated. By next paragraph, by referring to the decision of this court dated 17/5/2022, passed by a coordinate bench of this court in WPC 6902 of 2021, give a dash Abdus ABDUS Samad SAMAD versus the state of Assam and 7 others. It is submitted that similar clause 10 was examined in the said case, and it was held that clause 10 was a standalone provision, and the procedure prescribed therein is incompatible with the other terms and conditions. And it was also held that the said clause opposed the principle of equality enshrined in Article 14 of the Constitution of India and was discriminatory. And it was held that the said clause was held not to entitle the petitioner therein to insist that their tender should be accepted merely because a given tender is the highest or lowest depending on the nature of the bidding process. First off, it is clearly submitted that another coordinate bench of this court, while deciding WPC 4377 of 2022, Suruj SURUJ, next word Jamal JAML, and 3 others, versus the state of Assam and 9 others, decided by order dated judgment and order dated 23/11/2022, took cognizance of the decision of this court in dated 17/5/2022 in WPC 6902 of 2021. And upheld the validity of clause 10 of the said NIT, which is parameter to the clause 10 of the present NIT. First, it is submitted that the hearing before referred judgment dated 17/5/2022 was put to challenge in this judgment is not put to challenge. This WA 204 is not this.
204 is, my lord, against the order in WPC 27 of 2022,
It is submitted
That-
that
which is indicated in
is-
para 20. Which is indicated in para 20 of the in Suraj Jamal's case.
okay, it is submitted that a similar order was put to challenge by filing WA 204 of 2022. This was referred to in paragraph 20 of the judgment dated 23/11/2022, passed in WPC 4377 of 2022. However, no, first of however, it is submitted that in the subsequent order, no view was expressed with regard to the order, judgment dated 17/5/2022, passed in WBC 6902 of 2021. Next, per contract, the learned Additional Advocate General has submitted that the provision of the tender condition of clause 10 was under challenge in the proceedings of WBC 4377 of 2022. And the said clause was held valid in by this court, by the coordinate bench of this court. First, it is submitted that in the proceedings of WPC 6902 of 2021, the clause 10 of the NIT was not under challenge. And therefore, any observation made by the coordinate bench of this court in the said judgment dated 17/5/2022 was merely an obiter, OBITER, and was not the ratio of the decision, and therefore the said judgment would not have any persuasive value for the purpose of deciding the validity of clause 10 of the NIT. That's all.
Yes, Your Lordship, more why, Your Lordship, the clause 10 was never interfered in the earlier judgment.
That I mentioned. So it is also submitted that in the judgment dated 17/5/2022, clause 10 of the NIT was not interfered with. Next paragraph. Consider the rival submissions made in the matter. It is observed that in the proceedings of WBC 6902 of 2021, the validity of clause 10 of the NIT was not under challenge, because as per the facts of the said case, comma, the bid of the petitioner therein was non-compliant. And therefore, he sought, the petitioner therein sought to invoke clause 10 of the NIT so as to impress upon the court that he should have been given an opportunity to produce or furnish additional documents to make his bid valid. Mr. Under these set circumstances, comma, this could, by an elaborate discussion, had held that the clause 10 was discriminatory, and therefore the interpretation sought to be given on clause 10 of the NIT by the petitioner in WBC 6902 of 2021 was not accepted. By this court by refusing to give liberty to the petitioner under clause 10 of the NIT to produce documents, and accordingly the writ petition was found lacking merit and this was dismissed. Full stop. Therefore, comma, the court is unable to accept the contention of the learned additional advocate general of the state that unless clause 10, unless the validity of clause 10 was under challenge, comma, the observations of this court on clause 10 of the NIT in WBC 6902 of 2021 should be considered only as an obited. Next paragraph.
That is elaboratively discussed, Your Lordship, from paragraph 21 to 31.
Don't worry. First of all, in the decision of Arun Kumar Agarwal, AGGARWAL, versus State of Madhya Pradesh and others, comma, criminal appeal numbers 1706-1708 of 2021, decided by the Supreme Court of India on 2/9/2011. Reported in within bracket 2014 bracket clause 13 SCC 707, comma, the Supreme Court of India had extracted the meaning of word dicta from various authorities. First, para 21 thereof is quoted below. First, from the above, comma, this court finds support on the point that the observations of the coordinate bench of this court in WBC 6902 of 2021 cannot be said to be an expression of an opinion which was not necessary to support the decision reached by the court. Full stop. The reason is simple. Because in the said in the proceedings of WBC 6902 of 2021, comma, the petitioner therein sought to take assistance of clause 10 of the NIT to project that he should have got an opportunity to supplement his tender, which was not accepted by this court, which is a proposition not accepted by this court. Full stop. The court could not have taken an appropriate decision without applying its judicial mind on the scope and ambit of clause 10 of the NIT. Full stop. Therefore, comma, since only the pair of interim relief is being considered, no point would be served to have an elaborate discussion on the scope and meaning of the word obiter and as well as inverted commas dicta. Full stop. Next paragraph. Next one, it appears that although the decision dated 17/5/2022 passed by this court in WBC 6902 of 2021 was not placed before the coordinate bench of this court when WBC 4377 of 2022 was decided, but it is submitted at the bar that reliance was placed on judgment and order dated 17/5/2022 passed by this court in WBC 27 of 2022 within bracket Rafiqul RAFIKUL Islam versus State of Assam and others, which dealt with a similar proposition as was decided in WBC 6902 of 2021. Full stop. It is observed that the coordinate bench of this court had expressed no opinion on the previous decision of the coordinate bench of this court dated 17/5/2022 passed in WBC 6902 of 2021. Full stop. Next, it is further observed that in para 20 of the judgment in WBC 4377 of 2022, where the coordinate bench of this court had referred to order passed in WPC 27 of 2022. There is a reference to WA 204 of 2022,
Subsequently.
which was appealed, which was an appeal against the judgment passed in WBC 27 of 2022. Nonetheless, from the website of the court, it appears that the said writ appeal was dismissed on having been rendered infructuous by order dated 16/2/2023 by the division bench of this court. Therefore, what emphasis appears is that the ratio laid down, that the decision of this court in WBC 27 of 2022, which is similar to, which is stated at the bar to be similar to decision rendered in WBC 6902 of 2021. Attained finality. Therefore, the court is disinclined to follow the subsequent judgment of the coordinate bench in decision dated 23/11/2022, as by the coordinate bench of this court in WPC 4377 of 2022. And in this regard, the subsequent judgment, having taken a contrary view, would not have a binding precedent. This opinion is rendered only for the purpose of examining the interim prayer for interim relief, and is not a final opinion on merit, which is left open to be decided at an appropriate time. Next paragraph. On examining the pros and cons of permitting a tenderer to supplement documents which are not accompanying the tender, the court finds that there could be a situation where for specific purpose, so with specific intention, a bidder may not elect to disclose all the documents which he has. Full stop. In a tender process, the tenders are opened in the presence of the bidders. Full stop. Therefore, had the document been placed on record, it would be open to a bidder to question the correctness or validity of the document produced. Full stop. However, if by applying clause 10, a document which was never brought on record along with the original tender, and the other bidders lose an opportunity to raise an objection against the documents, and later on, the bidder, the highest bidder, places the document on record, and the authorities who are examining the tender accept the same. Such an acceptance of a document which did not form a part of the bidding process would be an ex parte acceptance in the absence of the bidders. This situation hits Article 14 in the opinion of the court, is hit by Article 14, as an equal opportunity has not been granted to all the bidders to examine the validity of a bid of a highest bidder. Full stop. It is also previously observed that bidding must be done in a transparent process. And everybody who are present in the opening of bid should be aware of what the of the nature of documents which are accompanying the bid. Full stop. If such an opportunity is lost, it cannot be said that the principles enshrined in Article 14 of the Constitution of India is not violated. Full stop. Therefore, the court finds the court is inclined to follow the earlier judgment of this court dated 17/5/2022 passed in WBC 6902 of 2021 to have more persuasive value than the subsequent judgment dated 23/11/2022 passed by a coordinate bench in WBC 4377 of 2022. As the correctness of the as in the subsequent judgment, the previous orders of this court was not considered by applying judicial mind. Full stop. In taking this head view, taking the aforesaid view, the court finds support from the constitution-based decision of the Supreme Court of India rendered in the case of National Insurance Company Limited versus Pranay Sethi, Pranay Sethi, within bracket 2017, bracket goes 16 SCC 680, where the Supreme Court of India had observed that disagreement with earlier judgment of a coordinate bench was impermissible. Full stop. Hence, being bound by the ratio laid down by the Constitution bench of the Supreme Court of India, the court would be inclined to accept the decision dated 17/5/2022 passed in WBC 6902 of 2021. Next para, hence, as an interim measure until the next returnable date, the respondents, the responding authorities. Who are the respondent authorities here? Who has to be restrained? The executive officer, Batadawa Anchalik Panchayat, will make a respondent number 5, and the president, Batadawa Anchalik Panchayat, will make a respondent number 6. Are prohibited from, are restrained from giving from taking recourse to clause 10 of the NIT. Dated 29/4/2023 for settlement of Ghat mean, the next word, Mahal. Where is the document?
The tender document.
Otherwise there'll be a mistake in typing.
Page 36,
30,
page 36.
36. No, 36 is SMS. My secretary will not
Page
find time
34.
to, huh?
Page 34.
34.
Lordship needs the memo number.
Because if you want the order after 7 days, then my secretary can translate. Otherwise, you'll have to give him translated.
Page 34.
34, 34. That serial number, huh? Bit number, so and so. Next column, however, comma. The said authorities while accepting bids, shall give wide publicity to the effect that clause 10 would not be applicable till will not be applied till the next date of receipt.
Your Lordship, the
This-
liberty may be given to us so that we can continue with the process.
No, we have not stopped it.
Yes.
Only that will be not
Only
available.
clause 10.
The next para. This order, this interim order cannot be understood as if the court has restrained the respondent authorities from proceeding with the settlement of the lien. So the only restrainment is the exercise of power under clause 10 of the bid. Correct. Anything you want to add? This,
May I pay for an observation? As your Lordship is suspending clause 10, some of the petitioners may be at liberty to participate without being prejudiced to the challenge in the.
no,
Because
that's
the
it. Why should you give that liberty? You always have that liberty.
Yes, yes.
Lordship will observe them.
No. Why should I observe it?
But
Why should I
otherwise,
observe it?
they will again take a ground that we have participated to this center process.
No, it's not.
Usually-
this.
Because I've challenged it NIT member. We have not
Because I am
partic-
permitting them to go ahead with the tender. So if you want, you can participate.
It is suspended.
Only clause 10 has been suspended.
Yes. And therefore, my lord, my challenge was only with regard to clause 10. Now your Lordship has protected me by an interim order suspending clause 10. I am otherwise I'm an eligible bidder who intends to participate. And my challenge in the repetition is only in respect of clause 10.
Okay, well, next one, it is also clarified that without prejudice to the challenge made in this petition, the petitioner would be at liberty to participate in the tender process.
High level. Okay.
You made statement in para 3, 2 and 3. I'll take up bail matters. There are 2 or 3 bail matters.
High level.
Me too. Me too.
Item 58.
Yes, 58 bail matters, 3 or 4 bail matters are there. I'll take up those first. Yes, NDPS matter. Where is the previous order of rejection?
Yes. Your lordship's idea is page 62.
62.
Not rejected by this court. It is
Oh,
not
no.
rejected by this.
Your
court.
lordship order one,
Yes.
page 20.
20.
Prior to the tax reform.
Last
Last
order,
part only your lordship will clear.
page 20 is the one.
We lend the order.
Yeah, page 33, my lord. No, page 32 bottom, paragraph 12, 30.
Page
Page 32, 33.
32, 33. Oh, I'm sorry. Yes,
Yes. Bottom paragraph 12. So that is a merit, my lord. Yes. Simple, it is distinguishable case. Present case distinguishable from the fact stated two case cited with the London Council for Routine over the investor. That is investor last two lines, my lord. Basically, the
okay.
investor.
Now trial has started.
My lord?
Has the trial started now?
No, our case was a charge sheet. In my case,
Part charge sheet
take
submitted.
your last page 61.
But I have seen that last time you made a submission about past charge sheet. I've seen that in respect of you,
Yes.
it's a complete charge sheet.
Yes,
And only in respect of those who are absconding,
Yes.
charge sheet was not submitted, therefore that
No, in my case, you have kindly see page 61.
page 61.
Yeah. Because my involvement only about that it is my from CDA, my voice. I was not present, my lord. On the basis of the co-accused statement, my lord. So page 61 you lost them.
Yes, 61.
Yes. It's charge sheet last part, my lord.
Yes.
Further, it is stated that the accused so and so is absconding and further attempt to arrest her and shall continue in the investigation after submission of this charge sheet. Now you lost it. The FSL you lost. This is
Expert opinion.
FSL expert opinion of the arrested accused among the present petitioner, which was sent in the marked document D29 is yet to be received. Therefore, the investigation into this instant case shall continue for collection of the further report and evidence in the governor section so as. So my question only by the CDR, whether my voice was there or not, whether I had contact or not. So that remains, that is to be investigated in respect of the present petitioners. And my involvement, your lordship will find only because of that only they say about CDR part. What is it to do? Charge sheet to this one. Yes. Maybe 61. So on the basis of that observation, my lord, can it be stated that part it is complete in my case, my lord? And on merit also nothing is required from the petition.
I don't know, you may be right, because it says that from the driver and you, there was communications.
Driver said that my lord, as per his, yeah, my lord, I have done it. So co-accused statement. That is, I am having a judgment of this court, my lord. Coordinate bench. I have given a copy, my lord. Can we have a look to that? About the co-accused statement. Of coordinate bench of this court. So nothing required from him, he was not there, man. Only on the basis of whether his telephonic talk with the driver, that is to be ascertained. That has not been done at the time when the.
No, that has come.
My lord,
That has come on record.
subsequently came. After that, subsequently it has come.
The last slide.
It is reflected, my lord, in page 64.
Hmm.
Rejection order. Subsequently, on 16/5. My lord, 180 days complete on 9/4/23. 9/4/23, your lordship. That is very important. Date is very important, my lord. And this is reflected in the order dated 16/5/23.
When it came, of course, they can say mine. But so far, when the charge sheet was filed, it was not there. Basic one, nothing was required from him. So question of file, chance of that conviction. Please, you know. There you go. Yeah. From paragraph 11 onward, my lord, the discussion. Nothing covered by on merit. I have two full argument matter on merit as well as on charge sheet, default merit. Yes. Hotel pieces nothing. Police decision display wasn't pretty soon. All doesn't. People say. Whether. Okay. Oh, no, 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 Paragraph 18, 19, my lord. 19 is.
Yes, I have read that.
Yes.
I'm right now in para 21.
19 you also got 19.
I've seen that. Now I'm at page 14.
Yes.
So you're on two grounds.
Yes.
First is that that no recovery was made from you.
Hello?
And first is that no recovery is made from you,
Yes.
and that you are being
I
implicated by a
present.
statement of co-accused.
I was not present on the scene also. my.
It's okay.
On the statement
And
of
that statement of co-accused,
Correct.
that is one. Second is that
charge sheet, default.
charge sheet was incomplete.
Yeah.
Okay, yes.
So far, my lord, regarding the statement as per learned, my learned senior friends regarding the relevancy of co-accused statement, my lord, I rely on the, my lord, the case of Mohit Agarwal's case, my lord, where a lawsuit has gone through, my lord, that's section 37, and when the relevancy of co-accused statement is taken into consideration, my lord, it is, and regarding the, my lord, regarding the, my lord, the search sheet, my lord, but there is no any word like part search sheet, my lord, and from the order of the, my lord, learned petitioner, my lord, it is very much clear that he has taken it as the complete search sheet, my lord. Only thing is that the one of two of the co-accused are absconding, that is why, my lord, the term that is used, my lord. So, my lord, and furthermore, my lord, on the basis of that, my lord, now it is only a bail petition, my lord, it is not a petition under, my lord, 482, my lord, was alleging that. my
No, no, he has to submit, Mr. Chaudhary has to submit because of the fact that court must arrive at a conclusion
Lordship,
that he is not guilty of the offense. So
Yes.
therefore, one has to argue on merit.
Lordship, and my lord,
One cannot avoid merit and then say that, regards of section 37 can also be,
yes, my lord.
but that
That's
argument can't be
what
made.
I have heard from my learned senior friend, my lord. And regarding the merit of the case, my lord, the lordship will find from the, my lord, page 57, my lord, of this petition, my lord. Your lordship.
You were arrested when? How many days?
Arrested on my lord, 12/10/22. 180 days complete on 9/4/22.
12, 10, 22.
12/10/22.
Yes,
Page
but-
18.
Yes.
What are
Regarding
you
the,
saying?
my lord, the materials against him, my lord, regarding merit, my lord, thus you may kindly see page 57 of the present petition, my lord, where the lordship will find in the search sheet, my lord, page 57, my lord, the
57.
last para, my lord, A, my lord, regarding Ahmad Uddin Tapadar, my lord, how he has been involved in the trafficking, my lord. May I read, my lord, this?
Yes.
He was the facilitator of supply of heroin between Mizoram and Tripura. Ahmad was arrested on the intervening night of such and such by tracking his phone near Sargulla, Karimganj. Two mobile phones were recovered from him, that is touchscreen phone bearing phone numbers such and such, and one keypad phone bearing such and such. IO carried out search of Ahmad and recovered a CCTV, hard disks, and some documents related to his business. Ahmad was arrested and brought to police remand for 14 days. During interrogation, he confessed his involvement in trafficking and named two accused, Larosingay and Palarangi of Aizawl, Mizoram, to the suppliers, and Luna and of Amtoli, Tripura, to the receivers. He confessed being involved in illicit drugs trafficking of 4-5 years, and that he recently opened a mineral water production company and a furniture house to legitimize his drugs money. The CDR of arrested driver Mohib and Imad was analyzed and found them to be in contact with each other multiple times on the day of seizure, including moments before seizure. Similarly, Mohib, Ahmad, and Munna all were in contact on that fateful day, and just prior to seizure proved that all three of them were involved in trafficking of the seized drugs. Further, in the interrogation of Ahmad, revealed that he had kept huge amounts of cash concealed in his house. Accordingly, IO made search in his house and recovered and seized 20 lakhs from the house of Ahmad. The income tax returns Ahmad for the preceding years were collected and found to be disproportionately low, which proved that seized money was proceed of drug trafficking. Further analysis of his seized touchscreen mobile revealed WhatsApp conversation with Mizo supplier, his name, which included voice notes of illegal drugs trafficking and pictures of laser printing or to payment of drugs money. The voice sample of Ahmad was recorded under Pro Consnama and in accordance with the certificate under section 65B IA, and the recorded voice along with seized touchscreen containing the illegal voice sample have been sent to FSL for the Superintendent of Police Karimganj for proper analysis and providing expert opinion. Further analysis of call records of Ahmad's seized phone number such were found to be registered against fake owners, while and two numbers were registered in his own name. However, Ahmad was in continuous touch with driver Mohib through his fake SIM and WhatsApp conversation with other person through this one phone number, my lord. From one of the registration documents of Amas Mineral Water, it is found that he had consciously entered a fake SIM as his legitimate number, thereby confirming his conscious position of the number. Apart from inquiry, a separate inquiry under 68E NDPS was conducted by IO against all illegal acquired properties of Ahmad and found it to be disproportionately high of 594% against the disclosed income. Is the details collected so far, my
Everything is my fault.
and my lord,
That remains to be investigated. 173, have a look to 173.
and
Can
from the
we
confession,
173 CRPC.
and my lord, from the confession statement of the
That
driver,
I am not disputing, my lord. That
your
what I am
lordship will find, my lord. This is the, my lord, seventh time, my lord. Before that, my 6 times he has made the transportation. This is the 7th time when he was caught, my lord. It is on the instruction of this petitioner, my lord.
No, this
So
person
he
is
is the
never.
very much
in anything
imprint
like this. Never.
in this, my lord, trafficking business.
No incident at all, my lord. Nothing.
Decisions are not there.
Yes. These income tax pay, my lord, he paid. But one day have 173, sub close to my. About default bail here, my lord. About the
Yes.
charge sheet part, mine.
Yes.
Your lordship got it, man. As soon as it is completed, your lordship, and that is very important. man. As soon as it is completed, the officer in charge of the police station shall forward to the magistrate empowered to take cognizance of the offence on a police report. As soon as it completed. Now, investigation. Now, definition investigation, your lordship, kindly see page minus section 2H. Definition investigation. Section 2H. Investigations include all the proceedings under this code for the collection of the evidence conducted by a police officer. So collection of evidence file. Once you collected all the evidence, once it completed, then only it is called to be charge sheet. Otherwise, it cannot be my full charge. Only to deprive me, my lord, to get that default bail that you are saying so and so on. And no antecedent, nothing at all, my lord, no spot, nothing, only one severe telephonic call, etc. My lord. And that remains to be investigated. That evidence not collected at the time when the charge sheet was filed. That is page 61. Right? It is their his observation. Right? IO's observation.
Yes, my lord. My humble submission, it is not only the, my lord, severe, it is also the my lord, the confession of his co-accused, my lord, which is really very much relevant at this point of, my lord, trial, my lord. My lord, I have also relied on, my lord, another judgment, my lord, very recently passed, my lord. I have given a one copy, my lord. The lordship can. Yes,
And Mohit
Union of India
Agarwala
versus-
distinguished one, page 30.
Union of India versus Ajay Kumar Singh, my lord. Just
Union, is that?
Union of India versus
it is Union of India versus Ajay Kumar Singh, my lord.
it's not done.
Just
Union.
now. My lord, this is only one copy. Here is a case, my lord, where my lord, High Court has granted bail, my lord, on the ground of clarity, my lord, but the London Apex Court has set aside that order of the High Court, my lord. And some observations were made, my lord. Lordship may kindly come to paragraph
Why so?
11, my lord. Mainly the bail is granted on the issue of, my lord, Article 21 of the Constitution, my lord. But, my lord, what the Learned Apex Court held, my lord. Lordship may kindly go to para 11, my lord. The information revealed by two accused persons indicated both of them knew the respondent accused and that they had connived with him to transport the illegal ganja and that they were in direct contact with the respondent accused all throughout his mobile number. The facts as unfurled from the complaint and the statements of the above two accused persons recorded under section 67 of NDPS Act reveals that respondent accused is the kingpin and the organizer of the illicit trade in ganja. Please, my lord. Here also, my lord, the learned request order relied on the section 67 statement, my lord. Thereafter, lordship will kindly come to paragraph 14, my lord. This apart, my lord, it is noticed that the High Court in passing the impugned order of bail had lost sight of section 37 of the NDPS Act, which inter alia provides that no person accused of an offence involving commercial quantity shall be released on bail unless twin conditions laid down are satisfied, namely, public prosecutor has given an opportunity to oppose the bail. Secondly, the court is satisfied that there are reasonable grounds for believing that he is not guilty of such offence and that he is not likely to commit any offence while on bail. And thereafter, paragraph 15, my lord, section 37 has been quoted, my lord. And thereafter, my lord, para 16, my lord. In view of the above provisions, it is implicit that no person accused of an offence involving trade in commercial quantity of narcotics is liable to be released on bail unless the court is satisfied that there are reasonable grounds for believing that he is not guilty of such an offence and that he is not likely to commit any offence while on bail. The quantity of ganja recovered is admittedly commercial. High Court has not recorded any finding that a respondent accused is not prima facie guilty. And thereafter, my lord, it reversed the decision, my lord. Ultimately, my lord, and the High Court's decision of granting bail has been set aside, my lord.
Okay.
We are not on 37, my lord. We are not on 37, on not on.
Because it's a
37.
I'll
commercial
fix it on
quantity.
14th for delivery of orders. 2 days I'll be traveling.
Yeah.
And whole question, my lord, it is based on phone call. Phone call is not investigation point. You were saying that. This is what basic thing.
Heard Mr. H.R. Chaudhary, and Senior Counsel, assisted by Mr. A. Ahmed, Counsel to the Petitioner, and Mr. M.P. Goswami, and an APP for the state. So, argument is concluded as the scanned copy of the case diary is voluminous, list on 14/6/2023 for delivery of orders.
14/6.
14. 2 days I'll be traveling. I
Lovely.
don't have- On today evening, I'll be on travel.
I am also not feeling well today, my lord, but I am two other matters also there, my lord. But that is short. 2 matters other matters. In the meantime, Mr. Ram Suikia's son, my lord, died. R.C. Suikia,
I'm so sorry. Oh,
26 years old, my mother, because of heat or something. Just now we got the information.
oh,
Our Ram Suikia's son.
I'm so sorry. You'll be a young boy,
Yes, young, was 26 years,
26.
26.
Anybody told you what is the reason?
He said it was just something uneasiness he felt yesterday because of the heat, my lord. I think. Taken to name care. He said because negligence of the doctor, my lord, that is what he's saying, my lord.
Okay. Just,
Right this morning.
just a passing remark. There's a test I forgot. It's calcium test. I forgot the exact medical term. Something to do with, it's a calcium test. It is required to be done of all young, of age 26 and plus.
26.
26 and plus. It says that there are deposits in the, what do you call, you do a ECG and it may not catch if it is, if calcinations are formed in the arteries. So it is only that calcium test, if done, will be, will allow you to detect whether there is a what do you call this calcineurin formation in the blood.
So if that
In
test is
fact,
done.
2 days back, doctor aged 41 years died in the hospital.
Yes, exactly. He himself also, my lord.
He is himself a
treated
doctor.
So many
He
patients.
felt uneasiness. He went there.
Very young, 45.
At the time of,
Yesterday, I think is a
immediately
doctor.
before his death, ECG was taken, he was normal and he collapsed and died.
He himself might have saved so many people also. This possibly.
Huh?
Recent case
Yes.
of Rajasthan matter, the doctor from Rajasthan.
Yesterday.
I forgot,
Only two.
He also has started-
Yesterday I have-
but because of that, I immediately I searched about about this causes and
Mr.
causes.
Yes.
And then I learned from the medical advices given that it is this test which is required to be done to find out. Since I have some interest, since I have some interest in medical, because I have some interest in medical, therefore when I find an opportunity, I read it.
Yes.
That's the only reason. But I'm so sorry, I have to find out. Mr. Shaikh is a nice man.
Yes, we are going there, madam, now.
Yes, item 59.
Yes, 59, 50, 61. 59, I have come already, my lord, total 6 PWs. And I take the straight away find out page 28 onward.
59.
You have kind of say page 20, my lord. Total 6% was cited as weakness in the charge sheet.
Yes.
Yes. Now, my lord, the subject to with a scan copy, my lord, to our information, my lord, by this time, 4 already exam. 4 already exam by this time. Subject to what subsequently last date was 6, my lord, I do not know what happened, my lord. Now you will kindly see number 1, page 28, PW1. Caesar witness. Yes. Total 3 Caesar witness, my lord.
Yes.
PW1, PW3, and PW4. Now he is to some extent supporting, but his statement also you will kindly see, my lord. Just I am getting my page 28, my lord. He said, my lord, House of Mizano, President Mizano, my lord. 3rd line, my lord, I along with Halek went near the police party. You also got it on page 28.
Yes.
I am reading my evidence of Aminur Rahman.
Yes,
who
yes.
is-
I along with Khalik went near the police
Khalik
party.
went there the police party and they asked us to accompany the police party. My wife Shantanu also came. Myself and Khalik were taken inside the house of Mizanur Rahman. You will kindly know. Now I take your worship to Khalik's statement, my lord. Just page 36, my lord. Just my lord. Page 36. Your lordship got page 36.
Just,
I know the
no,
informant of this
just.
case. Page 36, PW4. While I was
Hey,
going
just
from,
a moment, just a moment.
yeah, sorry.
Yes.
36. Khalik is saying, my lord, while I was going from mosque to my house, your lordship got it, man. Some police personnel met me near Tiniali, and I was requested by them to put my signature on a piece of paper. Then told me that they were going for a raid in the so-and-so village. And accordingly, I put my signature in the said paper, which was a blank paper. Now, wife, page 35. Wife of the of PW1. The PW1 said all my wife also gone, Khalik also gone, he also is. Page 35. Wife is saying, my lord. Page 35. I reached the place of occurrence after my husband went to the said place. Upon reaching the place of occurrence, I saw the police personnel were taking photograph Then I came out of the room and thereafter police requested me to put my signature in the seizure list. I do not know the content of the seizure list. I only saw the photographs were taken by seizure articles. I do not know anything about such photographs. So which one, my lord, if those three witnesses go, who remains, my lord, who will support the case? Only on that guy I have come before watching. There is the very big chance of conviction, my lord.
Regarding my lord, PW1, my lord, the lordship will find is very specific, my lord. Adjacent on the day of occurrence, I saw police personnel along with CRPF in front of the house of
Oh, that-
Mijanur.
that-
I along with Khalid went there near the police party and they asked us to accompany. My wife also went. And myself and Khalid were taken inside the house of Mijanur. Police recovered, that is the recovery is there, my lord. Police recovered tablets from the house. Therefore, my signature was taken in the seizure list, my lord. It is very specific, my lord. And regarding her wife also, my lord, she did not deny, my lord, somewhat, maybe some may not similar, not look like similar, but she did not deny that she was not present at the place of occurrence. She also tells, my lord, I reached the place of occurrence after my husband went to that place. Upon reaching the place of occurrence, I saw the police personnel were taking photographs and out of the room. And thereafter, police requested me to put my signature, my lord. That is the, my lord, PW3, my lord. And another one, PW is yet to be examined, my lord, regarding the seizure, my lord.
All the he cannot trust for the matter. Statement he has given, my lord. Because of the
Because
statement of Khalik and
At this
his
stage,
wife.
my lord, and regarding the, my lord, your lordship will find is, it is seized from conscious possession, my lord. 2,600 tablets and also, my lord, heroin, my lord, along with that, my lord.
Both that is.
And it gave positive test for, my lord, methamphetamine, my lord. And it's a conscious possession, my lord. It is not that, my lord, he is not present. my lord. And other witnesses,
It is not correct.
Assisted by Mr. Mr. A.T. Sarkar, counsels of the petitioner and.
it is also somewhat similar, my lord. 60, my lord. 60 of 60 of
Not same affair, sir. Next
Next
item, madam. Very short, I take only 5 minutes, man. For your lordship, madam, it will not take much time, madam. Your lordship, total 10 PWs. And PW 1, 2, 3, 4, I take your lordship. Page 30, 211, page 32. 32 informant, I'm not reading my lord here, informant.
Page,
Page 36 on 11. Seizure witnesses, man. The local witnesses. PW 1 is the my lord informant, I am not my lord, he has implicated my lord. Now page 36. PW 2, PW 3, PW 4, I'm reading. Page 36.
yes,
I know the informant of this case. I know the accused person. On the date of occurrence, while I was returning from Masjid after Namaz, everything in the morning, my lord. For your time, your lordship. This early morning, man. Police called me and took me to the house of the accused person, where my thumb impression was taken. Some packets were shown to me by the IC. I do not know where from tablets they were bought. There were about 23% present in the place of occurrence. That's much. Next, 37. Again, my lord, the local seizure witness. I do not know the informant of the case. I know the accused person. After offering my morning prayer, Fajr Namaz, I met police personnel and they requested me to put my signature in the piece of paper. I do not know the contents of the paper in which I put my signature. Then page 38. Page 4. These are the three seizure witnesses. Man. Page 38, PW 4. Same thing he's saying. After offering Fajr Namaz at about 5:35 AM, your lordship was mentioning yesterday about this timing, mind. Your lordship mentioned about a timing of Adim. That mind. Some police personnel came and requested me to put my signature in a piece of paper. I do not know the contents of the sheet. These are all the three statements. Now, on the face of it, whether it will make conviction will be there or not, my. Once chance of conviction is late, my lord, I think I'm entitled for bail. This is my one. More than 9 months. Both the person. More than 9 months. This much, my lord, my.
I would know this,
Another-
I would know this for different reason. In my formative years, I have lived my life in Latokia.
My lord. Very.
Other witnesses are yet to be, my lord, examined, my lord, out of 10.
The main eyewitnesses go, what remains?
Yes.
Nothing would remain.
And my lord, Nazrul is there, my lord.
Sometimes some cases are of course minor too. Sometimes we find my. Now people are coming from namaz in the early morning, you put somebody standard, if we just put
Here
signature.
also, my lord, from,
This is how that is.
she's from conscious position, my lord, 1600 tablets, my lord.
1600 Yaba
Tablets,
tablets.
my lord, and it is
Yes.
methamphetamine, my lord.
We are not on that.
All the cases, my lord, this is a commercial quantity.
Obliged to us.
Here also same. This is 80 circa. 14 for delivery of orders.
These matters, your lordship, relates to eviction in
Silasako.
In most of the cases, your lordship, in fact, your lordship, already this honorable court has passed several orders on those matters, your lordship. Although I am praying for a stay, your lordship, virtually, your lordship, my prayer will be limited to your lordship, seeking some time to relocation, your lordship. Since ultimately, your lordship, initial eviction took place, your lordship, the idea was, your lordship, that within 100 meters, the eviction will be carried out, your lordship. Now we are outside 100 meters. So we thought that we will not be evicted, your lordship. Now, since they have come, your lordship, and inform us.
Babujari, I find very big reasonable. You may speak to the authorities and get back to me as to what would be reasonable time to them to, if they want some type of relocation. I think we'll have to give them some time.
No, yeah, my lord, yes.
So they'll be entitled to some time.
Yeah,
Overnight, somebody is thrown out.
yes. This is the order passed by my lord. On a writ petition, my lord, which was filed, my lord, that has been disposed of, my lord, on 6/6/23, last 6, my lord. There, my lord has only given a leeway, my lord. It's only, my lord, a matter of giving a leeway of some amount of time to the petitioners, my lord, to make a representation before the deputy commissioner. And my lord, given
No,
undertaking,
you see, the reason for asking you is different.
my lord.
You see, even I occasionally give this example. You see, I'm hearing you without any intention of hearing you. Correct. We call it a semblance of hearing. Perfunctory hearing I am taking. So therefore, what I am intending is that the deputy commissioner, when he hears it, he must be reasonable. That communication, I think you'll have to make. So no point sending citizens to officers who will not listen.
No, because here, my lord, in the first line of decision, my lord, in Rupjuti Bora Borgohain, lordship has, my lord, seen it, my lord.
No, it's okay, but you see, what I want is that the authorities will take a decision, at least to be reasonable. Instead of the court imposing conditions.
My lord, at the end of the day, my lord, they will have to vacate, my lord. It will only, my lord, boil down to the point as to whether they can be allotted with any, my lord.
No, it's not even asking that. Mr. Bhattakur's statement is very simple,
My lord.
that for the purpose of relocation, he must need some reasonable time.
Yes. No,
At least in principle, that decision you can ask the deputy commissioner and come back and tell us, so that it is not always that the court is imposing a condition.
yes,
The
yes,
authorities,
yes, yes.
they will consult one or two people and we'll arrive at a decision that this is some citizen are giving a relief of so and so time. We are giving a notice of 7 days. Instead of these 7 days, we'll make it say 30 days or 15 days, whatever they think like. It should be a reasonable exercise. People who have been living in that areas for a long time, throw them overnight. So that's why when Mr. Watagos made a statement that this will boil down to this only, I think it deserves some consideration.
In the entire line of decisions, my lord, Justice made his decision and in fact, my lord's decision, which I have just now placed. This honorable court has only given a leeway of my lord a passage of time to my lord vacate. Seven except that, my lord, they are prima facie not entitled under the law.
No. Entitlement question of entitlement never is not even an issue here.
That's
The issue is that the authorities will give them a reasonable time.
yes. I
Correct.
will communicate and my lord, if my lord is taking that view of the matter, lordship will keep this, my lord, writ petition pending. Lordship will only, my lord, take up my lord on next Wednesday, my lord. Let this writ petition until Wednesday, my lord, lordship may protect them, my lord, till Wednesday. And by Wednesday, my lord, I will get the as to what is the,
Okay,
because
good enough.
it is again.
There
my
are 3 or
lord,
4
the policy-
matters. I'll hear it together and I'll pass orders.
Absolutely, my lord, no difficulty. Because it against my lord, I will have to take
The
instruction.
3 matters are of Mr. Bhattacharya.
Lord,
One is of Mr. Borgohain. You accept that submission of Mr. Bhattacharya?
Has already pointed out the most relevant point. We are not here to oppose the eviction that they have moved, my lord, but only thing is overnight, my old people, my children, it's not feasible for them to move. And on the last occasion, your lordship knows how it was undertaken. Because after demolishing my house, my lord, accommodating me will be something which they will not accept. Now, only thing is that, my lord, we are anticipating today morning,
Okay.
I have seen that they have gathered the police force personnel, they have barricaded the area. At any point of time, they may initiate, my lord.
Okay. Give them protection till Wednesday.
Till
In the
Wednesday,
meantime,
my lord,
you come back.
let them come out.
Yes.
Because
We are also my lord,
Just
this
right.
this may be a policy decision at the government level, so therefore.
That's right. That's right.
But I am submitting, whether my lord, that time period can be 7 days or 15 days or 10 days. But some parameters, my lord, definitely the government has undertaken.
It's ultimately the government is for people.
Yes,
It
my
can always mold
Yes.
reliefs. It's not always that you have to what you call be very hard. It can be
True, my lord.
it can be reasonably spread out.
Yes.
Nobody is opposing it. Just say
There are 3
Yes.
matters on board, my lord, in the list.
3 and 1 4.
My lord.
Four.
Yes.
My item is number 2, my lord. In this supplementary list.
Okay, I'll pass orders. It will
My
be
lord,
similar.
I will-
Only the names will differ.
My lord.
3 items,
My
Mr. Bhattacharya.
senior friend.
Item number 73,
74 and
75, 76, 77. Mr. S. Bhattacharya, counsel for the petitioner, and Mr. R. Bapuja, standing counsel for the Revenue Department, and Mr. M. Setial, and government advocate appearing for the state. No, it may be different in different cases. I'm just making and both are representing all the respondents. No, not both the respondents. GMC and GMD are there.
GMC, GMD, all are there.
You are there. GMC and GMD were represented by
J. Rasmani for S. Bora.
J. Rajkumari on behalf of Mr. S. Bora, standing counsel for GMC and GMD.
My lord, only one thing, my lord, in my lord's order, last order, my lord, that in that Timon case, my lord, there my lord had directed the petitioner to make a representation before the deputy commissioner, and my lord, that representation has to be disposed of within 13 days, my lord, Tuesday. And therefore, my lord, the deputy commissioner has been directed to take a call. Now, oh, my lord, that is still 13. If lordship may be pleased to fix this matter on 13, my lord. Then, my lord, perhaps, my lord, I can get the instructions. Because otherwise, that matter is fixed on 28th of this month, 28th of June. Lordship will
28-6.
13. Lordship will kindly come to my lord, paragraph 10 of my lord's decision. My lord.
I've seen that 13-6.
Yes, 13-6. So 13-6, my lord, will be a reasonable time.
the petitioner's hearing are apprehending imminent eviction in a drive which has been undertaken. I think this will cover. Same as para 2. Issue notice of motion returnable on 28/6/2023. Requisite extra copies of the writ petition be served on the Runner State and Department Council in course of the day. Heard both sides on the prayer for interim relief. First of all, in brief, the case of the petitioners is that they are occupying land under DAG number 602.
Mine is 602, my learned friend, Kiragala. 530.
530.
530, my learned friend, I'm
I see,
602.
So whatever is
Item number 1, my DAG number is also 530.
that's just one by one. I can't.
So far as my case is concerned, one DAG is 602,
302 in item number
is your lordship 75,
75.
and in 76, 530. 76, 77, 530.
530. Okay. Mr. You are item number 1.
I'm Mr. Item number 1, my DAG number is 530. Well,
530. Your name?
DJ Deka.
DJ Teka. Okay. And Mr.
My DAG
Ajbar, go ahead.
number 602.
Item 2, 602. Most of the petitioners claim that they have constructed their houses which are covered by holding number issued by the Guwahati Municipal Corporation, and they are enjoying electricity and other basic amenities in their houses. First of all, it is projected that without serving any individual notice of eviction, the respondent authorities are contemplating eviction drive. Full stop. It is submitted that the eviction drive is illegal, and it is also submitted that even if the eviction drive is imminent, reasonable time should be granted to the petitioner to make alternative arrangements. Next, the learned. This para 7 will be same. 7, 8 will be same. 9. Next para will be 7 and 8 are same. Then having regard to the submissions made by the Learned Counsel for the petitioners, that without any notice and eviction process is being initiated, and that a reasonable time would be required to the petitioners to make alternative arrangement, the court is inclined to grant time to the petitioner till tomorrow is a non-working day.
Tomorrow is a non-working day.
So the 13th will be too late, I think. Too early. They will not be able to
13th,
Monday,
Then-
Tuesday.
Monday, Tuesday. Then my lord may direct them, my lord, as per my lord, paragraph 9 of that decision, my lord, order. Paragraph 9, my lord, let them make a representation before the deputy commissioner.
We'll make it
Lordship-
14th, till 14th.
Yes,
they
yes,
will
yes,
make it.
yes, yes.
We intend to grant time to the petitioners till 14/6/2023 to make representation before the Deputy Commissioner, Kamrup Metro Guwahati, along with all supporting documents, and provide their respective email as well as mobile numbers containing messaging applications such as WhatsApp, Telegram, etc. And be prepared to give an undertaking to vacate the land within such reasonable time as the Deputy Commissioner, Kamrup Metro Guwahati may so prescribed. First of all, on such application being filed, the Deputy Commissioner, Kamrup Metro Guwahati shall sympathetically consider this representation and grant a reasonable time to the petitioner to remain in the house under their possession. Full stop. In the interim, comma, it is provided that till 14/6/2023 and of the consideration of the representation, whichever is later, you make it same as 10, 11, 12, 13, same. We're giving that protection till
We are
14
keeping-
and reasonable time till they take a decision.
Lordship is also fixing these matters on 28th.
Same, same day.
Yes.
Same, same day. Same.
The next date would be on 28th of June.
28/6.
28th. I'm deep there. And they will have to, my lord, make the representation before 14.
Till 14.
On 14th, we will be
Till
giving
14th.
anytime, my lord, it is always open to them. I'm obliged, my lord, deeply. I'm so obliged.
Because you see, Mr. Barpujari, there is another reason for that. You see, if a general indication is given by the authorities, then people may not have to rush to the court. You see, it's a dangerous situation where in front of the house there is a bulldozer standing, and then the person has to rush to court, catch advocates. Not catch is the wrong word, to consult a lawyer. Correct? And approach the court. It takes a lot of time. That can be saved.
This order is a balance order, my lord, it
No,
will balance
no,
the
no.
equities.
Coming
both the
to court is not very easy. Coming to court is not very easy.
Oh, that is true, but my lord, yeah, I will not make that submission.
You see,
From day one, my lord, the
No,
day
no.
they entered into occupation of the plot
no,
of
that
land,
is,
my
no,
lord, they
see,
knew.
so no, that is okay. No, that is okay.
My lord,
But you see, if without a uniform in a off day, go to any court complex, and you will find some people asking, what do you want, come here. So all these things are done. I have an experience which I may tell you. Although I'm spending we are very valuable time, but I still have to tell a story. You see, long back, some of our friend lawyers were discussing, and somebody asked me that in which class my son was studying. Then I remembered that I forgot to pick up my son from the school. I had to rush to school and found that my father had already picked up the school, had given a call to my house. My father came and he picked up my child and went back. Now, he was anxious that something bad would have happened to me because a father can't forget a son. So he came to the court complex. And somebody told him that I am no longer in practice. So they asked my father if they had if he had any work, he could help. He could help them. So my father knew where I sit. So he went there and gave information that is pick up my child. When I came there, I learned that my father had taken away the child. And I narrated this story on the next date to Mr. T.J. Mahanta, now senior counsel. And he said that, well, you are in a good shape. He had a worse experience. Correct. He said that a person came a few days back to inquire about senior Mr. Mahanta. And somebody told him that he is dead and therefore he can engage them. So the man was very sorry that the senior was no more. He said that, no, I have got a lot of experience with him. I will go to his house and meet him. How I never knew of this, I don't know. And then in the house he found T.J. Mahanta. And so next day T.J. Mahanta and the person, as told by Mr. Mahanta, came to the court and made several rounds to find out the lawyer who said that. A living man made dead, but he could not be traced. So this is the experience I have, and I must share with you. It's not for any other purpose, but to say that there are still some gray areas in some of the persons we know. And so it is not a very easy task for people to rush to court and get good lawyers and then made an effort. So this is what I intend. The intention is only that some reasonable options should be take policy decisions.
Pressure is on the either side, my lord, on the client also and on the advocates also, both sides.
Both sides must still That feeling, even after 20 years, I have not been able to.
My lord, Lordship has only, my lord, forgotten about my lord's son. Yesterday, I had, my lord, left my laptop bag, my lord, there in the parking. I kept it in, on top of a, my lord, motorbike, and I went home, my lord. And later in the 10:30, my lord, this car parking boy, he gave me a call. He found out, my lord, my laptop bag. There were some documents, my lord, he called me. He said that you forgot your laptop bag. This is how it happens, my friend. I was under some tension pressure, work pressure.
Fantastic.
What to do?
Fantastic. Yes, item 7,
I'm so, like,
bus association. Yes. Yes, you may make your submissions.
Yes, but if the petitioners first entered into a minutes of the meeting with the authorities.
Yes,
Initially, the authorities took a decision on 2006. Thereafter, we moved the trial court. Thereafter, they said in a minutes of meeting with us. Therefore, it was decided that this will be the process. Thereafter, again, they took a
where is that minutes? Where is that?
Uh,
minutes?
38 lot, 36 lot.
Okay,
38 lordship, it was incorporated in the order. 40, we withdraw the 40 lordship, we withdraw the title suit, incorporating that minutes of meeting. Thereafter,
yes,
yes, 40 lordship, we withdraw the title suit because we entered into a settlement that was incorporated in the order. Then again at page 43, the municipal corporation this time took a decision not to allow us. Then we moved the Honorable High Court. Honorable High Court at page 47 lordship, passed an interim order to allow us to continue as per the earlier minutes of the meeting. So 47 lordship is the final order of the court that has attained finality, allowing us to continue in this manner. Now, lordship at page 51, lordship will find the final order. Now, lordship at page 63 of the additional affidavit.
where is the final order page?
Page 51, operative part is page 53, lordship. Page 53, lordship. In view of the above assurances of the minutes of meeting aforesaid, this repetition is disposed of with a direction that respondent to allow the petitioners association to fly the buses, same association, lordship, to fly as per the terms and conditions laid down in minutes of the meeting dated so and so. That has attained finally. Now, lordship, at page 63 of the additional affidavit. Page 63. Lordship may take the additional affidavit.
Yes,
At page 63, at clause 7, there was again a minutes of the meeting with all the Upper Assam bus associations. At clause 7, the chair started the discussion relating to pickup stoppages for the buses. Travelers will be taken up after going through the records and orders of the Honorable Court. Meanwhile, the existing pickup points will continue. 9, all the buses will stop at the specified pickup point, stand, and will maintain the time interval at pickup. That was a decision again. 19. That was going on. Now, suddenly, lordship, at page 54. At page 54, lordship, they take a decision. At page 54 is the impugn orders. In pursuance to the decision taken in the minutes of the District Road Safety Committee Dibrugarh held on 22/2/2023 at 10:30 in the office of Deputy Commissioner Dibrugarh, hence stoppages of all type of buses and travelers will be immediately shifted from Dibrugarh town except CNG buses to the Muralidhar bus terminus Dibrugarh. Now it is taken by the Deputy Commissioner come the Chairman Dibrugarh Road Safety Committee. Now at page 55, the DPO only informs all the President Secretary of bus associations, two bus associations, including our association, to comply with the order.
Yes.
Lordship, therefore, my first count of argument is that the earlier order between the same parties have attained finality without, which is confirmed in the minutes of meeting at 2019, without giving any heed to the order which has attained finality without any review or appeal. They have altered the decision. Lordship. An executive authority cannot do that first. Secondly, the district deputy commissioner come chairman is not the competent authority. This is an area covered by the statutory rules. The section 67 of the MV Act and sections rule 73 of the Assam Motor Vehicle Rules.
Which provisions?
67 of the MV Act and 73 of the state rules. It is very specific. State rules is very specific. Lordship, we have quoted the rules also, or rules conditions. 73. Firstly, Lordship,
Motor Vehicles Act.
rules, I have given the specific section, Lordship, copy of the 67. These are conditions of our permit where to stop. Now, this can be altered by the issuer only. Power of the state government to control road transport. A state government having regards to consequences, the advantage offered to the public, trade and industry, develop and motor transport, the desirability and coordinating road transport so and so, may from time to time by notification in the official gazette issue direction both to the state transport and regional transport authority regarding passengers' convenience, economic competitive fares, prevention of overcrowding. Lordship, may I read 73? This is more specific. Lordship, stoppages, stands and halting places for public service vehicles. A regional transport authority in consultation with the local authority having jurisdiction over the area in concern by notification in the official gazette or by erection of traffic sign or both may either conditionally or unconditionally. We are covered by C. Declare certain specific places or place as stand for purposes of picking up and setting down of passengers and providing time and facilities to the passengers of public service vehicle and requiring a driver or conductor so and so. For a reasonable period, which in any case not exceeded 2 hours. Declare certain specified place or place of as halting place for the purposes of picking up or setting down of passengers or any public service vehicle or any specified class of public service vehicle, and also for providing rest to the vehicle and the staff thereof for a reasonable period, and shall in any case not exceed 12 hours. Where a place has been notified or has been demarcated by the traffic signs or both, one notwithstanding that length.
Just a moment, I'll tell you. You see, what has happened is, orthopedic doctor was concerned with the incidents of road deaths. He filed a writ petition before the Supreme Court under Article 32, which was converted into a PIL. That is reported in 2018-13 SCC 516. 2018-13 SCC 516.
Yes.
And there the Supreme Court in that PIL gave a direction that a district road safety committee should be constituted, which was an order passed under section 215 of the Motor Vehicles Act.
Right.
Now, after that has been filed, now each district is mandated to have this road safety week. Now, the in charge of this road safety commission has been constituted, and our former Chief Justice, retired Judge of Supreme Court of India, Justice A.M. Sapre, is the head in the entire country, and he is doing district-wise visits to find out the performance of the road safety committee. This is one part. So you see that the provisions of these rules are whatever you are reading will override the order of the Supreme Court of India, which has mandated that now the safety concerns will be looked after by a committee appointed under section 215 of this act. The observation of the Supreme Court is like this. The court issued the following directions. Number one, there should be a road safety policy. There should be a road safety council. There should be a lead agency, road safety fund, road safety action plan, district road safety committee, engineering improvement, traffic calming measures, road safety audit, engineering design of new roads, working group of engineering, drivers training, lane driving, road safety equipment, alcohol and road safety, others, and it goes on. So the entire paragraph is devoted to that. And then it says, we may note that none of the directions given by us or directions given earlier by this court are difficult to comply with. In this connection, we may draw attention of this excellent document prepared by the Committee on Road Safety, that is this committee. And therefore, it says that this will be followed, and it would be worthwhile if similar reports are prepared and published so that all roads in the country are rendered far safe than they are today. So this was a direction. So this road safety committee, I think after the Supreme Court judgment, that will override.
Lordship has asked me that whether it would be a binding precedent over the rules or not.
Article 142 makes it binding.
Yes, Lordship, but 142 is an exception to the rule of binding precedent firstly.
When it is of this of the issue which is the subject matter of the Supreme Court, I can't hold that the judgment of the Supreme Court will have no binding effect.
And secondly, Lordship, the section 67 or 73 is not taken note of, Lordship. Therefore, the statutes are not taken note of. That is my contention only. Because Lordship has asked me about the precedents. Therefore, firstly, Lordship, it's an order passed under 142. Secondly, the statutes relating to
This was an order passed under Article 32.
32. Then also, Lordship,
It was
statutes are
a
not.
writ petition under Article 32, which was converted into PIL, and then orders were passed. And the orders of the Supreme Court under 142 will be binding. So I can't possibly have an option to say that this order will not be binding. Therefore, I can only issue a notice at this stage.
Lordship,
I have two submissions.
2 days, Lordship. May I place some judgments on that? But I have come
You
across some
see,
judgments.
I'll tell you, there's not one judgment. There is a series of judgments of Supreme Court after this, which has laid emphasis on the road safety committees. That's not only one. I think there will be 5 or 6 cases. Yesterday I tried to find out. There are 5 or 6 cases where emphasis is given on the district road safety. You take time. I don't.
Yes, Lordship, but
I don't have
Lordship,
time.
kindly, Lordship, for a moment, I will not press on the law. For a moment, Lordship, from 2006, they have been in discussion with us if they want change in the bus stand till 2019. Now
No, but
suddenly
we
this
can't-
order have been passed, Lordship.
we can't give liberty to the persons, individuals to decide where they want to stop, where they don't want to stop.
Lordship, I just, because of the hardship caused, Lordship, therefore, Lordship, on the other day pointed out Guwahati. In Guwahati also, I inquired, there are 4 stoppages in the city outskirts, but there are 4 stoppages. In Khanapara, Bokista, Lokhra and ISBT. It is difficulty for the passengers also to from one point.
Okay. Wednesday then.
Wednesday. I'm sorry, Lordship, but
No, it's okay, because since the matter was there, I had to do some research and come.
Lordship, but that the High Court
Lordship,
issuing the earlier order was completely different. No? So Lordship is taking up on Wednesday. No? Lordship,
Okay.
Lordship.
and there was an instruction whether it is fully functional or not.
It is there. A functional
Yes,
certificate
that
has come.
instruction we have placed.
Instructions has come.
Lordship.
That instruction has come. Mr. B.P. Bora, counsel for the petitioner. Mr. D. Nath Leonard, senior government advocate. Miss M.D. Bora, Leonard, standing counsel for the transport department. You are there? No. Are present on the prayer made by Leonard counsel for the petitioner list on 14/6/2023. 14/6/2023.
Lordship, may I keep my instruction in the part of the record?
No. Because
Lordship.
I'm different.
just one more thing.
My lord.
In the Supreme Court, one of the orders, I won't remember it immediately unless I search it.
Lordship.
There's a direction that that in terms of section 215A, you will be the state government will be notifying the competent authority to take decisions. Any such authorization has been given because now he's taking a plea that the deputy commissioner is not an authorized person.
I will get an instruction.
Lordship. RTO or any other also, we'll get this.
Because that goes to the root of the matter. Under 2.1, this is 215A, I think. There's a requirement that the state government can empower persons to take up the matters. Just look at this. Item 5.
power of the road safety councils and committees.
Heard. Just write little shorter, sir. Heard Mr. A. Barwal and counsel for the petitioner. Mr. G. Sharma, learned standing counsel for the FTN border matters, as well as Mr. K. Gogoi, learned additional senior government advocate. Next para. At the outset, the learned standing counsel for the FTN border matters has produced a copy of communication under memo number capital MRG /B /2023 /352 dated 6/6/2023, wherein it has been stated that on an inquiry conducted by the police personnel, reference was initiated against Abu Sahid, wide FT case number 8/2022, and after completion of the inquiry of the said reference, the said reference was forwarded to the learned member of the Foreigners Tribunal, 5th, Morigaon, to register a case. And accordingly, FT case number 449/2023 has been registered. Full stop. In view of the said information, which is kept as a part of record, the grievance raised by the petitioner appears to have been addressed, and accordingly, in view of FT case being registered against the respondent number 5, this representation stand closed.
I'm obliged, my lord. I've taken steps today, my lord. Initially, my order was to take steps or 17 actually, but wrongly typed as 7. Subsequently, it is corrected. So it does give you some messages. I have taken steps.
Okay. Mr. S. Das, counsel for the petitioner, submits that he has taken steps today
Today, my lord.
for service of notice on the private respondent.
17.
Mr. MD Balan and
Standing counsel.
standing counsel for
Transport Department.
Transport Department is present. List out of police awaiting service report. 25.
Also, this interlocutory application has been filed for including the opposite party number.
Just a moment. You want to implead whom?
For including the opposite party number 3 also, because the
Number
department
3.
has been
You are appealing for
Respondent 5.
respondent 5. There's no respondent 5 here.
Lordship.
There's no respondent 5 here.
He may be appearing for the containment number 1 also. Post to record.
No, I don't know. If he does not know, I can't record his presence. He must know from whom he is appearing. There's no respondent for 5. This is item number 25. You all are young people, you should be energetic. Don't you read the brief at your home? You read it here.
Lordship, I am appearing on behalf of SP Das.
No, whatever brief, but you must have a habit of reading brief at home, not here, or your chamber, not here. Heard. Mr. S.K. Das, Learned Counsel for the petitioner. Mr. Your name?
A along,
A. Alam, Learned Counsel, appears on behalf of
SP Das. SP Das.
SP Das. Learned Counsel. However, he does not know for whom he is appearing.
Standing Council of Assam Skill Development Initiative Society, SP das was.
I don't know, one is doesn't say, I record that only. Does not know for whom he is appearing. As per this interlocutory application has been filed for implementing opposite party number 3 as respondent number 3 in the connected contempt petition. It is projected that by a notice dated 8/4/2023, the new incumbent to the Office of Secretary to the Ministry of Skill Development and Entrepreneurship was put to notice to comply with the order of this court, which has not been done till date, according to the opposite party number 3 is allowed to be implemented as respondent number 3 in the connected contempt petition. This application stands allowed. In the contempt petition, you write, in view of the order passed today in the connected IS Civil 1090/2023, the registry shall impede the opposite party number 3 therein as respondent number 3. To stop pending correction of the cost title, the letter notice returnable notice to respondent number 3 be issued returnable on. Give a date of fixed date after 5 weeks. The petition shall take steps within 2 days for service of notice on the newly implemented respondent number 3. List on so and so. Let's
Sorry, as for respondent number 2, I have available and I filed affidavit.
Okay. The pendency of this contempt petition shall not be a bar for the newly implemented respondent number 3 to comply with the order of the court. Here, Mr. K.K. Parashar, you write appearance of Mr. K.K. Parashar for respondent number 2, and in their opposite party number 2 in the IU. Okay.
26/7. 26.
26.
Same order.
Same order. Okay. Now you now you know from who you are appearing. For whom?
I am appearing for the sole respondent.
Sole respondent.
Respondent.
Newly implemented respondent.
Sole respondent. No, there are 2 respondents here again.
Earlier 2, Malak, yes.
No, acha, sole respondent Kasturi Bharali. Okay. Now write his name as appearing for the sole respondent in the main case. IA same. Implementing of opposite party number 2 as respondent number 2 in the connected contempt petition.
Party number 3.
Same order.
Opposite party number 3.
How 3?
Uttul Kumar Tiwari.
Achha, you will be for respondent number 1. You will be for 2. Mr. K.K. Parashar for respondent number 2. And now the new opposite party number 3 is respondent number 3 in the connected contempt petition. Same order as earlier. Okay.
Lordship has given returnable date on.
Take it from the court, Master.
26.
93. 93.
May I please, Your Lordship? Lordship, initially this repetition was filed challenging the order dated 13/2/2023 passed by the district magistrate Golaghat,
whereby the Batsmith plant, which we are operating, the petitioners are operating, was stopped. The operation of the Batsmith plant was stopped on the ground that we do not have the requisite permission. This is contrary to the record of the case.
Yes,
NOC from the Gaon Panchayat was obtained, that is at page 25. Then Lordship, it is in a patta land, the Jamamandi I have annexed at page 23. Then a trade license was granted by the Gaon Panchayat, that is at page 38. And consent to operate from the Pollution Control Board, that is at page 49. Lordship, all these were obtained. And thereafter, we have started the operation of the plant. In the meantime, initially they have served one letter to us.
yes.
That is at 19/7/2022. This is the only letter we have received from the PWD department.
I
that is
am
an
only
annex
inclined to
and-
issue a notice, Mr. Tamuli.
Lordship,
You see what has happened here. You have filed this writ petition. Correct.
Lordship.
This writ petition was listed
On 15th,
On-
there was a mistake on my part.
on 24/3/2023,
Yes, Lord.
1/3/2023, 10/3/2023,
Yes,
and 15/5/2023. Correct.
yes, Lord.
Motion was never moved. And now you have filed an IA for an interim order.
Lordship, what happened in this
Without
case?
issuance of notice, why should I give you an interim order?
Lordship,
Your interim prayer is there in this writ petition also. You never pressed it.
yes, Lordship, I have placed it because on the first day, the instruction was sought for. They could not produce the instruction that what I have violated. Because nothing was given to me and in the imperial order, they referred to a letter.
Not at this later stage. I am not granting an ex parte
Lordship,
injunction.
on that instruction was called for and thereafter the matter was not listed. On 15/5, there was a mistake on my part that I could not appear. That is why on that
No,
day,
but motion is not going to go. We have not
the
issued any
earlier
notice for
occasions, I have-
anyone.
on each and every occasion, I have prayed for the interim order because of their.
We have not notice issued to anyone. PWD is not put to notice for the matter being taken up. You have for PWD.
Lordship, till next returnable day.
No,
please
no,
wait.
we are not opening our industry without, when there is already a closure. We can't allow your writ petition by an interim order. That principle I'll apply.
Lordship, then a short date may be given because I am suffering because my cements are here.
It's okay, but you see, motion was never moved for so many long.
Lordship, actually
time.
instruction was sought for from the department and department could not produce the
okay.
what I have violated. And the guideline that I have annexed in the miss case, that is the only guideline available, which they have, probably that is the guideline they have stated about.
Okay,
And that guideline says that they.
I don't know, they'll have to bring in instructions, in fact. I'm issuing a notice, short notice of 2 weeks. And Mr. S. N. Tamili Leonard, counsel for the petitioner. Also heard. Mr. K. Gogol and an additional senior government advocate appearing for respond number 1 and 2. As well as Mr. V. Chaudhary Leonard, standing counsel for PWD appearing for respond number 3 and 4. Next paragraph. The petitioner projects that it had set up a batch mixed plant on a particular plot of land after obtaining no objection certificate from PONCA, PONKA, Gaon Panchayat for setting up the plant. And he had also obtained the requisite trade license and consent to operate from the Pollution Control Board. However, by impugn order dated 13/2/2023, the district magistrate Golaghat within bracket respond number 2 had closed the operation of the plant with immediate effect without putting the petitioner to notice of the violation he has committed. Hence this writ petition under Article 226 of the Constitution of India. Next, issue notice returnable. Notice including notice on the prayer for interim relief as made in interlocutory application number 1423 of 2023. Notice is made returnable on 2 weeks, give a date. 26/6/2023. Just have requisite extra copies of the writ petition we served on the respondents in course of the day. Next one, on the next date, as the industry of the petitioner is closed, on the next date, the respondents should obtain necessary instructions if affidavit in opposition is not filed by them. I've given notice on about them. You get the information, why it has been closed, some reason must be assigned. Mr. Govey.
33 and 34 correctly, sir.
In fact, Mr. Govey, all these things are multiplying and choking the court. And somebody's office is closed, no information why it has been closed. People will come here only for information. I think that must stop at one point of time. Yes.
33, 34. I pay for the petitioner in both the matters, Your Worship. In 34, Your Lordships, today I have received an affidavit.
Expeditious disposal of the repetition.
Yes, today, Your Lordships, in the afternoon, I have received an affidavit. In the second writ petition, which is 2746, 2022 by the government.
Can we have it on 20 June for hearing? You exchange whatever affidavits you want to do, 20, since there's a division bench order to hear it expeditiously. You fix it for hearing on 20.
May I say this, Your Worship, because I need 2 weeks' time, because this affidavit has to, the reply has to come, my clients are in Hyderabad. I need at least 2 weeks. So any date after that, Your Worships, or it can after.
Because after that, there's a vacation on the last week, we can't do anything. It goes after vacation then.
Let it be done before vacation, my lord. There is some urgency in the matter in urgent says, my lord, although we have been given the work order, we have not been able to start because of the tendency of this petition. Let it be before the holidays, my lord.
Two masters can't be satisfied.
The question is, my lord,
I have a technical problem because my clients are not here, so I at least need 2 weeks' time.
Mr.
Immediately on reopening, I have no problems.
Mr. Fukan has to go to Hyderabad.
My lord, now it is communication, my lord, filing affidavits.
Because last week I have to keep myself free because last days if I spend time on hearing, I'll not be able to complete the motions which I'm having. Admission matters are taking a backseat. Part 2 I have not been able to touch. In fact, when I take up part 2, nobody is present.
Except few, my lord.
Except you, yes. You're right, there are exceptions. Then 22nd, make it by 22nd.
Let us give a try. Let us give a try.
Can it be 27th, Your Lordships, is not a problem.
22nd.
Okay.
Also as a duly represented. First, taking note of the court takes notice of the order dated 3/3/2022 passed by the division bench of this court in WA 77 of 2022. The I think expeditious hearing of this writ petition. Next, Mr. R.B. Fukan, the counsel for the petitioner, submits that he has received a copy of affidavit in opposition filed by
Agriculture Department.
State, today,
by the state on
today.
today. And he,
Lordship, in respect of 2746 of 22.
There are two
petitions.
Acha,
In
in-
830, Lordship, we have already filed.
In item 34.
okay, in
2746.
WPC 2746 of 2022. And in this regard, he prays for some time to obtain instructions and to file affidavit in reply if so required. Full stop. Next para. Mr. M.K. Chaudhary, Lawrence Senior Counsel,
Question number three.
along with his instructing counsel. You are there,
Chaudhary.
Mr. A. Chaudhary.
Ujjwal Chaudhary.
How you Chaudhary, I'm sorry, I forgot. You Chaudhary, counsel for the private respondent.
Question number three, yes.
Number three, submits that said respondent has not been able to carry out the work because of the pendency of this writ petition and expresses urgency in the matter. Next, but as agreed to by all sides, this on 22/6/2023. Just before that, you right? Next, para. In view of the nature of dispute raised in this writ petition, both these writ petitions, comma, the writ petition stands admitted for hearing by issuing rule returnable forthwith without requiring the petitioner to take fresh steps. Then you write, this is the matter for hearing on, as agreed to by both sides, is the matter for hearing on 22/6/2023.
All right.
35.
Yeah, this is your lordship. Actually, my senior's maternal uncle passed away this morning. So he could not come. Kindly the matter be listed after a week. We have taken the concern of the other parties.
On the pair made by and counsel for the petitioner, matter stands adjourned today. But now it goes after vacation. Day start and saying summer vacation.
Lordship,
Is that next of kin matter?
is that prayer Lordship has already gone through? What is that absurd prayer has been made with regard to
It's okay, but I don't want to discourage young lawyer who has come to make a prayer. But this revenue circle you could find out, because I don't have time to now search about that next of kin certificate, the validity of that certificate. It is under the executive instructions. It has. You'll find it in general circulars. I don't have time to read now. Correct. The validity of a next of kin certificate is for a limited jurisdiction. Give me that, otherwise I find it very difficult. It is, so far as I remember, if my memory serves me right, it is for debts and securities not exceeding rupees 2,500. But if you ask me where, I won't know. Ask your revenue people to find out and give it to us. Several matters of next of kin certificates are pending. All can be disposed of. A bunch of, I think, in this court only 10 matters can be disposed of, next of kin matters. Try to get those. Monday you'll be ready with that next of kin certificate. Okay.
36.
Wait, please. In this case, Lordship, the Ministry of Road Transport and Highways, Lordship, we initiated a process for acquiring land alongside the National Highway 29. Lordship, in this process, they issued a notification wherein the land of the petitioners, the descriptions of the petitioner's land was incorrectly mentioned.
This can't be rectified here. You'll have to approach the authorities and do it.
We have approached the authorities also.
Where is that?
Lordship, we kindly turn to Annexure 3, page 38. Lordship, may kindly turn to 33 page number first. In the notification, they have mentioned the department where we have to address, Lordship, Joint Secretary Revenue Department.
Karbi Anglong Autonomous Council, you are there?
For the KAC, Lordship.
Yes. Why you are not correcting the land records?
Lordship, we have obtained the instructions. We have obtained the instructions.
What
I
did it
think,
say?
Lordship, it says that the land area acquired by the NHIGCL for the construction of 4-lane on the plot of land is 0.0381 hectare.
Mrs. Bora will have to stay this, what do you call this? Process unless you do the rectification. You see, come to page 22.
Lordship, the land was acquired by the Kala Competent Authority for NHIDC for widening the road. That 3N as per my instruction, Lordship.
No, you come to page 35. It is your notification.
Yes, 3N gazette notification was published, Lordship, earlier.
No, correct.
So, however, Kala could not finalize.
No. You see, this is page 35. Is the what do you call this gazette notification?
Lordship,
Correct.
35.
Page 32.
He says that his road is, his land is commercial. And that finds support. Even at page 34, he has given the description of 2 plots of land. As
Yes,
serial number 17 of both the
That
page
is 3
34.
Yes, Lordship, that is 3A notification.
And in the next page, he shows that it is a commercial. Now the petitioner is referring to the Jamabandi at page 22. Whether it is right or wrong, I don't know. It is
Lordship,
commercial.
Here,
Bari.
the assistant.
Lordship, what it is 3A notification was issued, Lordship, that is true, page 34. But however, Kala could not finalize the objection under section 3C of the National Highways Act. So again, the 3A has been lapsed on 21/11/2022.
No, I understand.
So-
But you see,
Then has to
Mrs.
be
Bora, the
equipped.
difficulty is that 19/12/21, he gives an objection. 21/22/23, Kala does not have time to do it.
Actually, they have to do acquire the land, they have to.
No,
go
but if
for
they
the-
can't
any
have
objection,
it to disband that Kala,
Lordship,
ask them why to do it.
they have to hear the objection, Lordship, as per
If
section
Kala can't do
3A.
it, you find some boga. He can't do anything because if for 3 years you don't have time.
So objection, they have to hear, Lordship. Under section 3C.
No, I understand. You want me to give them an invitation card? We'll send it through the superintendent of
Lordship, why
police.
they are not doing, Lordship.
We'll,
That is-
we'll
that's
send
their
him,
job.
we'll send the card through superintendent of police. Give them some space in jail where they can work peacefully, no disturbance. You'll get food timely.
So actually, Kala has to finalize the 3A notification.
But who is this Kala?
Competent authority, that is Karbi Anglong.
We'll
Land
send him
acquisition.
to, we'll send him to safe custody. No
Okay.
disturbance.
Lordship,
Superintendent of jail will give him first class facility. I will read what you call the police manual. Mr. Kaustav Gogoi was kind enough to gift one to me. I'll read the prison manual, give him the best of facilities.
Lordship, if you can fix the matter for another day so that my senior can appear for it.
Yes,
No,
a long
senior will
time-
not do it. Just tell them, otherwise we'll give them adequate space, time.
Long time they have not finalized, Lordship. They are
We'll give them
competent
space, time of their own
Kindly next week.
next week. But ask them to do something. If they don't hear it, then we will give them what you call space, time, facilities. First class facilities. Superintendent of jail will be there to take care of you. Correct. I'm taking responsibility in saying it. And I'll ensure that this happens. The redundant counsel for the petitioner has referred to where is that to annex 3 of this writ petition. The project that an application was made before the Joint Secretary Revenue Competent Authority of Land Acquisition, Karbi Anglong Autonomous Council on 9/12/2021. And although the land of the petitioner is a commercial land, it is acquired as a residential land, which would deprive him of the adequate land acquisition compensation. First off. Next, Mrs. R. Bora, and it's standing counsel for the NS,
456.
for the respondent numbers 4, 5, and 6, NHI, NHI DCL has submitted that to her information, the said CALA, Karbi Anglong KAAC has not taken a decision till date.
The hearing was done.
Full stop. It is observed that for the inefficiency in the on part of the said CALA, Karbi Anglong Autonomous Council, neither they are doing the assigned work of adjudicating the objections raised by the citizens whose land are acquired, on the other hand, the court is being burdened of this litigation just because the CALA, KAC does not have time to do its work. Next para. Therefore, the Joint Secretary Revenue Department of Revenue, Karbi Anglong Autonomous Council, competent authority of land acquisition, in bracket CALA, shall be personally present before this court on 16/6/2023. He is put to notice to show cause as to why is this inefficiency should not be noted, and the Principal Secretary Karbi Anglong should not be directed to record the same in his ACR. Full stop. On personal offense, the Joint Secretary Department of Revenue, CALA, shall inform the court about the time which he proposes, within which he proposes to dispose of the objection raised by the petitioner. Next para, the learned standing counsel for the Karbi Anglong Autonomous Council shall transmit the copy of the order to the respondent number 3 to put him to notice to show cause. List on 16/6/2023 for personal appearance of respondent number 3.
I'm appearing for Union of India.
Okay, Union of India, your name?
P. Swargani.
P. Swargani for Union of India. Yes.
Regarding item 47, Manoj. The lottery fixed it pretty even then, but because of the possible time.
Which item? Please come this side.
I am the highest bidder. in
Which
this case,
item?
47. But in spite of that, there was a writ which was filed by the person who has not considered, whose tender was not considered. How he has challenged my awardment.
7. Who's there for 47?
Lordship, I am from Transport Department, my lord. We have filed our affidavit.
No, the petitioner should be here. N. Hawk or S. Huda. You have told them we will.
He is not here. Because so my agony is that I am the highest bidder. There is no stay order from the High Court. My learned friends should consider my settlement.
Okay. Another question, this This matter has been updated and taken up. First of the learned counsel for the petitioner is not present. First of Mr. S.C. Vishwas, learned counsel for the private respondent number 9 has submitted that although there is no stay order operating in this writ petition, the respondent authorities,
As member 4, my director.
the Director Inland Water Transport has not taken any decision for settlement of ferry service of
Buragaon.
BHURARGAON dash Badlichar BADLICHAR comma via, you just see page 1, huh? Number so it's a long name, page 1 of the writ petition. 1 and 2. First of all, Ms. M.D. Bora, Leonard, standing counsel for the Transport Department. Shall obtain instructions as to what is the impediment in the statement of the tender.
Lordship, they have taken the consent from me also, taken legal opinion. I have said this is matters pending.
It's okay, I'm just wanting a instruction, because if there's no stay order, why?
Yes, Lordship, then they may settle. Lordship, may kindly
I'm
observe.
not saying anything, because
My lord.
counsel to the petition is not there. I'm just wanting an instruction.
My lord.
I can't pass an order advice when the party is not there after 4:30.
Then we may settle.
You
May I
take a
please
call.
your lordship,
Take a call.
lordship with regard to item number.
List, the list on. You list it on after 2 weeks.
My lord.
We'll give you a fixed date, 1996.
Lordship, item number 53, 54, and 55, Lordship, it's with regard to distribution of maize and Napier slips to the farmers, Lordship. There is some urgency, Lordship may take it up on Wednesday with liberty to upgrade, Lordship.
We are the petitioners, my lord, in those writ petition.
Okay,
We also are expressing some
50,
urgency.
53, 54, and 55.
55. Okay, both sides are present. Urgency is expressed in the matter. So due to positive time, matter could not be taken up today. List of 17, sorry, 14,
Yes.
6, 14, 14/6/2023. Okay.
We have an interim order here. Can we?
Into our past tennis, now extended till the next date of this thing.
I'm obliged.
Yes, Mr. Sheikh, just wait, Mr. Sheikh is present. Yes,
My pharmacy license is not provided by the authority.
44.
44.
Oh, who is for health? Health will be who's there? Just see item 44.
Lordship, I think he has left, Lordship, Mr. Glover.
No, I understand this, not a good time. You have passed from where? From which institute you have passed pharmacy?
I have given this personally.
What is your name?
Jawaharlal Nehru Technological University.
Alia Nuri Sultana.
My name, Alia Nuri Sultana.
Correct. Your candidature is rightly rejected. Your candidature was rightly rejected.
No, my lord, it is not, it is rejected, not in a proper manner. My lord, it is not placed before the pharmacy council. It is as per pharmacy council, my lord, act. It should be placed before the pharmacy council. Without placing it, my lord, my case has been considered.
No, pharmacy council has, your secretary has rejected it.
My lord, that is not the process, man.
No, you see, Mr. Sheikh, I understand it from our registry. You file a writ petition which is defective. The registry does not send it to the court. And you say that the dismissal of the writ petition must be in the court only. If you don't have the basic qualification,
No, my lord. You should have basic qualification, my lord, that I will place before the lordship. But thing is this, there is a procedure prescribed.
no,
The
you
Pharmacy
see,
Act.
you'll have to satisfy me now, otherwise I'll dismiss the petition. You see,
No,
the
no,
reason is very
Your
simple.
lordship, my humble submission before your lordship. There is a procedure prescribed under Pharmacy Act.
I understand, but if you don't
Okay.
fulfill the criteria,
Okay.
essential criteria, why we should encourage the repetition? You see, what has happened? Your regular BSc examination was in the year 2017.
Yes, sir.
You failed there,
My lord.
correct?
Physics.
And then you appeared in physics. And then you appeared in betterment examination.
My lord.
And before that, you got admitted in pharmacy council. You couldn't have got admission there.
My lord, that is the question, my lord, that why university? University allow my admission. I passed out.
Oh, for that, answer is very simple. Answer is very simple.
I made them party. My lord, I am. a
Answer
poor
is very
person, my lord.
simple.
They took me admission.
Mr. Sheikh,
I passed out.
Mr. Sheikh,
My lord,
I feel proud in saying that I come from the civil court.
my lord,
So your remedy lies in civil court. You ask for damages compensation.
my lord. My lord, if your lordship, after hearing my petition, it is dismissed, then civil court will come, my lord. Then I will go to the civil court, no problem. But he is.
No,
this, my lord,
then you may
rejection
not,
is not proper.
then you may not even get an opportunity of going there.
Rejection, there is a procedure, my lord. Without following the procedure.
If you don't
my-
have, just only one question. While you took admission in the pharmacy council, pharmacy institute, did you have the basic qualification? If you don't
Under
have,
University I have, otherwise why they give me the admission?
Not
Under the
acceptable.
university, my lord, it is university, what I have.
Not
done,
acceptable.
not every university, my lord. Here,
in other matters, you make a mention before the court master. After I rise, just
My-
wait for 5 minutes. I'll complete this matter.
There's some interim matter to decide.
Tell the court master
My
one by
lord, my
one.
lord, I just need to extend my interim order, my lord. Item number
Tell the
82.
court master.
your lordship. First, your
Yes.
lordship would be pleased to see the rejection order,
Yes, I have seen that.
my lord.
Part of it I have gone through. I just, unless I open the file,
Page
I won't
44,
remember.
my lord, page
Huh.
44, 45.
Yes.
This is my application. My application registration, registrar, Assam Pharmacy Council,
Yes.
application for fresh registration. Now your lordship would be pleased to see here,
Mr. Sheikh, I have gone through
the
it. You see, I'll tell you.
applicant has failed in physics.
I'll tell you.
2017. Yes,
I'll tell you, you see,
my lord,
your betterment examination in physics
my lord.
was, the degree you got was in 2020.
Yes, my lord,
And the entrance into the pharmacy
my lord.
was in 2017.
Yes,
You show me the 2017 regulation
Hello.
of the eligibility criteria. Just show me that one piece of page.
my lord, my humble submission before your lordship is this. That actually, that particular university, your lordship will look into. Particular university taken me in admission. How they take this admission, my lord? So, my lord, what will be my assumption? I have been given admission. I have passed out from that university. Now, your lordship, they are rejecting that you do not pass this physics examination. And there is, your lordship would be pleased to see the original rejection order at page 45.
45.
Yes, my lord.
I've seen that. I'm at page
Yeah.
45.
And your lordship would be pleased to note that last paragraph, my lord. The applicant has failed physics so and so. Who passed this order, my lord? Your lordship see below. No signature, nothing of the sort. no seal, etc. Who signed it? It is not the way, my lord. It is under an act, Pharmacy Act. It should be properly rejected. Yes, all right, I do not have qualification, but can it be treated as an rejection order? Who passed this order, my lord? There is no number. There is no memo number, nothing of the sort. And signature, my lord, it is a short signature. Who passed it? Secretary is to pass it. No signature, no seal. How there can be a rejection order? Proper procedure prescribed in Pharmacy Act, my lord, that it should be placed before Pharmacy Council, and Pharmacy Council, after due consideration, rejected the petition. Where is the placing of my petition before the Pharmacy Council, my lord? Your lordship would be pleased to take this. And only thing is this, your lordship, how it can be assumed that the secretary of the Pharmacy Council rejected it, my lord? No seal, nothing of the sort, no memo number. Is it the way? Rejection can be, but it should be in a formal way, an official order.
Now the Pharmacy Act is new act or still the old act, 1996 Act?
My lord, 48.
No, it will be 1996, I think.
My lord, that answer is not with me, my lord. I have the Act of Pharmacy Act 1948. 60, if there is 66 Act, my lord, that is not available with me now. Your lordship would be pleased to see section 31. 48 Act, my lord.
61,
31,
31.
section 31. My humble submission before your lordship, first one is
Just
this,
a moment.
that cannot be a rejection order.
Just a
Proper
moment.
sense of the town. How that can be?
Thirty-one.
31, madam. I am referring to 31. A person who has attained the age of 18 years shall be entitled on payment of prescribed fee to have the name entered into the first register EV resides so and so many. But I also refer to section 30. Preparation of first register. There is a tribunal, my lord. The first is that the state government shall by notification on the official gazette continue a registration of tribunal consisting of so and so person. And that tribunal is to decide. There is clear procedure, my lord, for deciding. Registration tribunal shall examine every application received on or before the appointed date.
Which is the university?
My lord, university, my lord, I am giving.
Where is your certificate?
My lord,
Which page?
pass certificate, my lord, I am giving.
It is the university, my lord, your lordship pointed out. Jawaharlal Nehru Technological University, Hyderabad.
My lord, may kindly come to section 33 also, lordship.
Just a moment.
Lordship, lordship.
Your lordship certificate at page 43.
Yes.
So, my lord, your lordship will turn to page 43. It's
43.
provisional certificate. From my personal.
Yes.
Now, your lordship, first they rejected, my lord, and thereafter your lordship would be pleased to see page 49. A list of pending files of B Pharma for registration.
Yes.
So, Arialuni Sultana, my lord, at page serial number 3. Now your lordship will consider that rejection order, and thereafter this list said that my case is pending. That is also contradictory. And your lordship, just I humbly submit before your lordship, can it be a rejection order like this? I have given the original also, my lord. I have filed an application immediately. Fail in physics. Fail in physics. This is has been written, and thereafter applicant has failed in physics. So and so somebody signed, my lord.
No designation, nothing of the sort. Well, an order is to be passed under a statute. In this way, an order cannot be passed. There should be memo number. And that tribunal is there, that is not placed before the tribunal. All right, if I am not entitled in law, I will not be given, no problem. But this is not the way of
See,
eviction.
against this lordship, my lord may kindly peruse section 33 of the Pharmacy Act, lordship. Section 33 of the Pharmacy Act.
It will not substantiate, my lord.
Section 33 of the Pharmacy Act, lordship.
Okay. Uh, Heard. Mr. M. A. Sheikh Lamed, counsel for the petitioner. As well as Mr. K. Gogoi Lared.
Lordship, I am for respondent number 9, lordship.
Lared standing counsel for respondent number 9.
Lordship, the CGC,
Acha,
lordship.
CGC, okay. Lared CGC appearing for respondent number 9.
Lordship.
Mr. B. Gogoi Lared standing counsel for the Health and Family Welfare Department appearing for respondent numbers 1, 2, 3, and 4. Now the appears and call for respondent numbers 5 to 8. Next paragraph. Agreed by the rejection of the candidature of the petitioner for registration under the Assam Pharmacy Council, comma, the petitioner has approached this court under Article 226 of the Constitution of India, comma, praying for a direction upon the respondent authorities, upon the Pharmacy Council of Assam to register the name of the petitioner as pharmacist under the council. And for setting aside the rejection of the candidature of the petitioner by an informal rejection order dated 7/12/2021 within bracket annexure 25. Next paragraph. The case of the petitioner, comma, in brief, is that she had obtained a B Pharm degree from the Jawaharlal Nehru Technological University, Hyderabad, by provisional certificate dated 9/10/2021 by securing first class Full stop. The learned counsel for the petitioner has submitted that the Assam Pharmacy Council has to operate within the set of rules, and that the informal rejection order, which was passed on 7/12/2021, does not bear any seal or signature or any serial number. And therefore it is, and therefore the order was, and therefore it is stated that the order was not passed in accordance with law. Next, the learned counsel for the petitioner has also submitted that it is not in dispute that in the BSc course, which was being pursued by the petitioner, she
Higher secondary.
as a higher secondary, which was being pursued by the petitioner under the Board of Secondary Education Assam, she did not clear her physics subject. And thereafter she appeared in her betterment examination. It's a betterment examination?
Yes.
Betterment examination in physics subject, which she had cleared in the year 2020. Where is that?
My lord, I'm giving you. Betterment examination.
2020, full stop. Nonetheless,
Your lordship will turn to page 38.
Physics in the higher secondary final examination 2020 conducted by the Assam Higher Secondary Education Council. So it is submitted that pending clearing of the physics subject in higher secondary level, the petitioner was offered admission in which college?
Lord, Anurag College, my lord, that
In the Anurag
Pharmacy College.
Anurag Pharmacy College, ANURAG Pharmacy College.
Approved by AICTE, New Delhi, affiliated to Jawaharlal Nehru, Hyderabad University. Page, your lordship would be.
Which
pleased
is
to see page-
affiliated to
Page 40, my lord.
Jawaharlal Nehru Technological University, Hyderabad. And on successfully clearing the B Pharm course, the petitioner has acquired the
Bachelor of
degree
Pharmacy.
of Bachelor of Pharmacy. Hence, it is submitted that the petitioner is entitled to be registered as a member of the Assam Pharmacy Council. Next paragraph. For contra, the learned CEC has submitted that the basic qualification to get admission in the B Pharm course is that a candidate should have passed his higher secondary examination successfully with requisite percentage. And in the absence of the same, there is no way that a provisional admission could have been granted to the petitioner. Accordingly, it is submitted that there is no irregularity in the rejection of the candidature of the petitioner, as she had admittedly cleared her physics examination higher secondary physics examinations in the year 2020, while she was admitted into the B Farm course in the year 2017. Full stop.
And
In-
Losida,
in-
Before my,
page 46 also.
before my passing out the pharmacy course.
My Lord, may kindly page
Before my
46
passing
also,
out the
Lordship.
pharmacy course.
Page 46 is a letter issued by the Registrar cum Secretary, Lordship, Assam Pharmacy Council of India, Lordship. They have
46.
page 46, Lordship.
Full stop. It is submitted that
Non-acceptance of
Yeah,
registration
then-
of pharmacists. Lordship.
that by a letter dated 18/4/2022, the registrar cum secretary, Assam Pharmacy Council had written to the joint secretary to the government of Assam, Health and Family Welfare Department about non-acceptance of registration of the petitioner under section 32 within bracket 2 of the Pharmacy Act. Most of it is submitted that they said that as enclosure to the said letter, the names of various candidates whose candidature was rejected was provided. Most of it is submitted that the degree was obtained in violation of the guidelines prescribed by the Pharmacy Council of India in the Education Regulation, 1991, 2021. Sorry, 2020 for diploma in pharmacy and 2014 for Bachelor of Pharmacy course. Next paragraph.
Even Lordship, section 33 also provide for Lordship.
Alternative, the remedy of appeal.
Lordship, appeal
Next
before the-
one, It is also pointed out that under the provisions of section subsection 3
Lordship.
of section 33 of the Pharmacy Act, 1948, there is a provision for appeal before the State Council,
Lordship.
which and that the said remedy has not been exhausted. Next paragraph. Having heard both sides, the court finds that the eligibility criteria for admission into a B Farm course, B Pharma, it is B Pharma,
Lordship.
PHRMA, B Pharma course, is that a candidate should have passed class 12th board examination with 50% aggregate mark in the science stream with physics, chemistry, biology, public maths. Accordingly, it is the court is constrained to observe that that at the time of admission into the B Pharma, Bachelor of Pharmacy course, the petitioner did not have the essential eligibility criteria. Full stop. There is nothing on record to show that the Jawaharlal Nehru Technological University, Hyderabad had permitted admission of the petitioner provisionally, awaiting a successful completion of the physics paper in higher secondary course. Full stop. The the so-called rejection order, which has been referred to by the petitioner, is merely a note from from some dealing clerk, public assistant, public officer, that the applicant, that the petitioner had failed in physics and as such not eligible for registration. And had failed in physics in 2017 and as such not eligible for registration. And that the petitioner had enclosed a mark sheet for betterment wherein she has passed out physics in 2020. Which does not make her eligible for admission on B Farm course in 2017. First off, this is a mere request to the Registrar of Assam Pharmacy Council that the said authority would be pleased to, that the said authority may reject the application. First on, by no stretch of imagination, the court can accept that the said note to be a formal rejection of the candidature. However, the communication dated 18/4/2022 by the Registrar Cum Secretary, Assam Pharmacy Council, addressed to the Joint Secretary to the Government of Assam, Health and Family Welfare Department, within bracket page 46, bracket close. Sorry, not make it annexure 26 to the petition would constitute a formal rejection of the candidature of the petitioner for acceptance for registration as pharmacist. Next paragraph. Accordingly, the court does not find this to be a fit case for interference with the rejection of the candidature of the petitioner. Nonetheless, as pointed out by the learned CEC, there is a provision under section 33 within bracket 3.
53, my lord.
33. 3 of the Pharmacy Act, which entitles the petitioner.
Affiliate provision or 32.
33(3), which entitles the petitioner to make an appeal before the State Pharmacy Council. Under such circumstances, while dismissing this petition, the court is inclined to provide that the rejection of this, the dismissal of the petition shall not be a bar for the petitioner to make an appeal before the State Pharmacy Council under the against the rejection of a candidature for registration as provided for under sections 33 within bracket 3 of the Pharmacy Act 1948.
My lord, there is a time limit.
I'll do that. That's what I'm doing. Next paragraph. This petition was filed on 6/12/2022, and therefore the period spent from the date said date till the date of passing of this order from 6/12/2022 till till 36/2022 or such time till the or such time prior to 36/2022 till the petitioner files an appeal, the said period would be entitled to be considered as a time spent before this court in litigating the matter, which would be liable to be condoned. So accordingly, next paragraph, with the liberty as granted above to approach the appellate authority, this petition shall stand dismissed Full stop. Next para. As indicated above, the dismissal of this repetition shall not prejudice the petitioner when appeal is filed before the authorities.
But the only thing is, I may be excuse me, regarding appeal provision, my lord, your lordship referred to section 32,
33.
33, 3. Yes, ma'am. Apply it.
So this will not prejudice you.
Okay. Apply it. Lord, I'm grateful to your lordship. Your lordship has heard me, my lord, after all the time.
No,
And,
no,
at least,
it creates some,
some
No.
order has come, my lord.
no, it's okay. It creates some difficulty in the administration. What happens is that
My lord.
I am taxing myself because I have spinal injury. I have slip disc of L3, L4, L5. I can't sit for long.
Amen.
So number one, I am harming myself.
Lord.
Number
Lord.
two, the court support staff, they don't get the relief
Lord.
because I'll be here till 8 o'clock signing the documents and files. So nobody gets a rest. So that is the difficulty. They are all good people, they don't complain, but the difficulty is that everybody has a optimal level of working.
Well, your lordship given me consideration. I'm thankful to your lordship.
No, it's okay.
Much obliged.
It's okay. Because you expressed some anxiety, therefore I took it up, but
My lord.
it's not good for my health.
Okay.
And how's Mr. Pathak now?
I know he's recovered. He's still in Delhi. Still in Delhi, he's recovered.
Okay, well, what has happened? Actually, I did not call him. I did not know.
My lord, general body issues, my lord. He's gone for a checkup, of a full body checkup, my lord.
Okay. Some of it is-